Good evening. Welcome to the regular meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Commissioner Studley.
Here.
Commissioner Han.
Here.
Commissioner Rennie.
Here.
Commissioner Liu has an excused absence this evening. The first item on the agenda is public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Good evening, Commissioners. I'm Larry Bush. I write for City Report. Earlier this month, at the end of August, I asked the Commission staff to provide me with a list of those people who had not yet filed their Form 700s. And I have that list for you now. This is about 30 San Francisco officials who, by the end of August, had still not filed their Form 700s. Some of those people are included at that time: the Vice Chair of the Treasure Island Development Corporation, or Development Authority, as well as all three members of the Bond Oversight Committee, which, as you know, is the committee that monitors several $1 billion in funding. When I asked what actions had been taken to provide fines or what have you for people who had not filed, since these reports, as you guys know, since you filed them, are due on April 1st, I was told in writing that due to a lack of resources, there were no fine letters that were going out this year, and none had gone out last year. I talked to the FPPC, and they said that actually they had fined some San Francisco officials themselves for failing to file. Some of the same people who had not filed last year had still not filed this year. And I think that since I didn't see any mention of this in the Executive Director's report, that it would be worth the public being aware of the fact that there's this level of noncompliance with what is a state law implemented by the city, and that it should be a policy of the Commission to act to enforce that provision. So that was one thing. The other thing I wanted to point out is that the agenda for tonight did not include minutes for the 26th, their July meeting. It was not attached there. It just mentioned that you were going to vote on the minutes. It would be nice if you could put that over to the next meeting so that those of us who had not seen the minutes prior to this meeting had a chance to comment on some of it. Thank you.
Good afternoon, Commissioner Herr and Ethics Commissioners. I'm Patrick Minuteshaw. I'm troubled that you have scheduled my two cases on today's agenda. It's unethical for the Ethics Commission to even decide a case involving your own executive director, and the whole case should have been transferred to another jurisdiction, not just for developing a recommendation, but for holding any sort of public hearing on the matter. Mr. Chatfield, when he transferred my case to San Jose, noted in the cover mail, quote, "The Ethics Commission regularly handles referrals from the Sunshine Ordinance Task Force. However, it cannot adjudicate these matters as the executive director is a named respondent in both complaints." End quote. So it should be argued that the Ethics Commission has admitted by Mr. Chatfield that it cannot hear any part of either of my cases, even whether to dismiss the complaints or to calendar a full hearing on the merits. So your agenda that indicates the Commission is going to deliberate this case is a pure conflict of interest. There are others. Formerly, Task Force member Whitney has recused himself when hearing the Richard Moe case because Mr. Moe had led the charge against Mr. Nee's wife. Similarly, Mr. Rennie's wife, Louise, has been the subject of several of my investigations about Laguna Honda Hospital. including the Patient Gift Fund. And her foundation that refuses to release any Form 990 IRS tax return, income, and expense statements. So at the very least, Mr. Rene should follow Mr. Rickney's lead and recuse himself from this discussion. But what I'm asking you is to take this off your calendar and transfer the cases to another jurisdiction so that there is not perceived or real conflict of interest. Thank you.
I'm Alan Grossman. The Commission and its staff's decisions and actions must set the standard of ethical behavior and conduct expected from those in San Francisco's government that serve the public. Their ethical behavior is the foundation for the trust placed in the Commission by San Francisco's voters. 2 agenda items today test whether the actions of the Commission and its executive director meet the standard they should exemplify. The first, agenda item number 3, consideration of draft amendments to the Commission's regulations governing the handling of complaints alleging violations of the Sunshine Ordinance. This is staff's 3rd attempt to provide a suitable set of Sunshine regulations. The Commission staff submitted the first 2 to the task force for review and comment. This one, 5 months after your April joint meeting, was not. You may not be aware that the task force has been unable to conduct business for 4 months for lack of a handicapped member and has canceled its October meeting. In May, the Board of Supervisors appointed 6 new members, 5 of whom had never been to a task force meeting, and since May, the appointment of the task force member lawyer has been held up by the Board. Does the proposed action in bypassing a non-functional task force that cannot provide any input meet the Commission's standard of ethical behavior? The other is Mr. Minette-Shaw's case. The agenda says at this meeting the Commission will deliberate the San Jose Attorney Office's recommendation regarding the complaints. As Mr. Minette-Shaw quoted the referral letter, Mr. Chatfield stated, the Ethics Commission regularly handles referrals from the task force. However, it cannot adjudicate these matters, as the executive director is a named respondent in both complaints. Who decided that the Commission's hearing a public access case against its own appointed executive director for a violation of law was not inconsistent with the Commission's standard of ethical behavior? Thank you.
Good evening. You're on item number 2?
We're on item number 2, yes.
Great, thank you. This is for legal counsel. This is for the chair. I don't have any other copies. I'm going to direct my my statements specifically. By the way, my name is Bruce Wolf. I'm the past vice chair of the Sunshine Ordinance Task Force. I want to draw your attention to items numbers 6 and 7 on your agenda regarding the closed session. I believe that they are posted incorrectly and I'm just going to quote and refer to the Brown Act because that's the basis of the Sunshine Ordinance. You have the opportunity to meet in closed session, to meet with legal counsel to determine whether you should meet in further closed session and be if you are party to a particular litigation. But you must then state on the agenda what the item is about, and the charter cannot trump that. So I've listed the items of the statutes of the Brown Act in order based upon the order of which was stated in the agenda. So in item number 6, it's 54-956 starting in 7, it's 54-957.1, And you'll see on the sheet that I printed up, it's in bold. Prior to holding any closed session, legislative body shall disclose in an open meeting the item or items to be discussed in the closed session. Number 6 would probably not be covered because you're just going to be talking with your attorney about whether or not you should be in litigation or not. Further down in the next section, because it refers to 57.951, 57.1, in the first sentence, approval given to its legal counsel to defend or seek, blah, 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 and then to enter as an amicus curiae in any form of litigation. This would be your litmus test to determine whether you are eligible to enter into litigation or not. That further references 54.956.9. In the last sentence, for the purposes of this section, litigation shall consider pending when any of the circumstances exist. A litigation to which a local agency is party has been initiated formally. We wouldn't know that because we don't know what the item really is about. And then we don't know what would happen during the closed session, of which in section C of the same section, if the session is closed pursuant to the above section that I just stated, the body shall state the title or otherwise specifically identify the litigation to be discussed. None of that is posted.
Good evening, Commissioners. My name is Hope Johnson. Good to see you again. I'm the immediate past chair of the Sunshine Ordinance Task Force. And 2 things. One, I wanted to echo the comments of the earlier speaker about the minutes not being available online as an attachment. Those are some pretty significant hearings, and there are a number of people who would like to have opportunity to read them before you approve them. And then the second thing I wanted to, I don't know if this is the appropriate time to address this or not. There are a number of us who do feel, as Mr. Grossman stated, that while the task force is unable to meet through no fault of its own, it's difficult for them to participate in your regulations. But if you do choose to go forward, could you please provide some comment to the public about how you'll handle public comment on the points? There are maybe 36 decision points, and there are a number of issues we have with them. Just as an example, there's one section that says that you're going to impose a statute of limitations, and we don't know where that authority comes from. So there's a number of things we'd like to address, but we wouldn't be able to do it all in one sitting. So it would be helpful if you would give us some guidance on how you intend to handle that. Thank you.
Next item on the agenda is, I'm sorry. Mr. Warfield, I wasn't sure whether you were waiting for the next item or not.
I wasn't sure whether you were ready. Thank you. I'm Peter Warfield, Executive Director of Library Users Association. As usual, members of the public have given some wonderful comments and pointers and notes. Certainly, I would add to Mr. Grossman's comment that not only has the Sunshine Ordinance in its full regalia been unable to meet, but neither have, of course, any of the subcommittees which are supposed to be doing follow-up on prior matters and decisions and so on. So the Sunshine Task Force has essentially had its knees been shot in the knees and is unable to function in any way whatsoever for the public. And consequently, I would certainly agree with prior speakers and say that the agenda item, which I would have quite a bit more to say on, particularly with specifics, you should consider postponing action. It's a little bit dismaying to come into the room and find 12 items that I counted on the table, and not one single one appears to be listed as an explanatory document. Now, are you telling me that between the time that the agenda was posted and these materials were provided to the members of your commission and the public, there was nothing available at the time this agenda went out. You are mandated to show what the explanatory documents are that have been distributed to your body, and to do so on the agenda. Otherwise, there is absolutely no way for anybody to know that there are documents available and have been documents available. And as a matter of fact, thanks very much. An immediate disclosure request that we sent was very promptly answered and provided for through your office, and I appreciate that. But to not have that on your agenda is to violate the law, as well as to make it very difficult for yourselves and the public to even know that there are documents available at all. I did want to say something which I may mention again briefly in general, and that is you're dealing with very serious issues here, particularly in general with the Sunshine Ordinance and its enforcement. These are not just petty things, somebody didn't give somebody a document. These things are crimes against democracy itself. These are crimes against the whole way in which we expect our government to function and for the press to function. And so these are very serious and should be considered very seriously. And in general, you'll find, if you hear what I say, that I'm in favor of strengthening rather than weakening Sunshine. Thank you.
Good evening, members of the Commission and members of the community, both in this room and in San Francisco. I watched the Ethics Commission meeting, the final hearing on 911, and I was stunned that there was no court reporter. All through the Amir Karimi hearings, there's been a court reporter. There's no way to reference transcripts from SF.gov TV, and I don't care what any of you say, none of that is a court reporter, and we all know that. And I was stunned that I couldn't read any of the minutes that you approved, 1, 2, 3, 4. And you, Mr. Hurd, didn't even know if the minutes went all the way back to April or were we starting in May. And I counted, 7, 8, 9, 10 meetings of minutes that were finally approved all at once, and I had no way to read any of those minutes. At least I couldn't find. Well, I'm a disabled person, and I represent the disabled community, and damn it all, when we can't read this stuff, and you guys just railroad someone who's running them right out of a job, elected with 10,000 more votes than Ed Lee. And I can't believe it. This whole Ethics Commission is in violation of the Brown Act. This is a misdemeanor. All of you are committing criminal misdemeanors. Shame on you. I've told this to Scott Wiener. This is grounds for recall for him as a supervisor for his violation of the Brown Act on May 24, 2011. There were other violations of the Brown Act on May 24, 2011. The building that I live in, our parking lot at JFK Tower, was sold illegally. There was a fraudulent conveyance of hundreds and hundreds of thousands of dollars of public property for private gain. I don't know if the purchaser is a campaign contributor to Mayor Ed Lee, because at that time in May, he wasn't running for office. Remember? Run, Ed, run. And there was no violation of the extortion laws in the state of California, right, Mr. St. Croix? $80,000, and there's no ethical violation of the mayor's Run, Ed, Run campaign? Give me a break. And now one of the head people of that campaign is Supervisor Alagi. Shame on her. Nobody should vote for her on that. This is incredible what's going on in San Francisco, and I'm sorry I didn't have a chance to prepare my comments in a 150-word statement in advance.
Good afternoon. My name's Decha Bowler. I'm new to this commission. What I know I get from newspapers or reports from people or watching the videos of things that happen, and I'm concerned because I think that the any actions that you might be contemplating today should be held off, because I have to jump back to the situation that I think preceded the dismissal of the Sunshine Ordinance Task Force members. I believe that they were dismissed because they criticized the members of the board who were responsible for an action that involved a friend of mine, Kathy Lentz, who, when she spoke out of order at the relevant Board of Supervisors meeting, she was forcibly removed unjustifiably. She was held out. She then came back into the room to get her backpack, but she was then, that's when she had her arm twisted behind her back and she was forced out of the room. She was handcuffed. She was held downstairs here for a half an hour and had the good fortune of being spoken for by the Sheriff Hennessy's assistant, whose name I can't think of right now. Otherwise, she'd have been taken downtown. I think that the persons in charge of that meeting should have seen to it that the bailiffs or whoever those officials are called would not have acted in that way. And at any rate, that puts this commission in the position of acting on a matter that involves that resulted in the task force not being in session for I don't know how many months, but you need their advice to make the decisions on the matters that are in front of you, and it's all, I think, a very big mess. And I felt the need to speak up because a responsible citizen who was here because of the Park Merced eviction that was going to happen to her after living there for 25 years was upset and broke a rule, not violently. And I think that behavior is
Good evening, David Pilpel. Nice to be back again. Wanted to make a brief comment on one of the items in the minutes. It's actually not about the minutes themselves, but one of the statements that was made. And I'm sorry I spent the summer not following the proceedings that you all went through. Congratulations on getting through that. But the statement at the end, just before adjournment, Chairperson Herr stated the documents submitted by individuals who are not a party to the matter will not be included in the record. Perhaps at this meeting or thereafter, Chairperson Herr can explain to me the basis of that exclusion. The way I read the charter section, the proceedings before the commission were to be compiled and transmitted to the board, and it did not suggest to me that there were specific parties to the action that was actually a public matter before the commission. So I don't exactly see a basis for excluding material submitted to the commission by parties or non-parties. It seems that everything that was related to that proceeding should have been included in the record transmitted to the board. But perhaps if you have a different view, we can discuss that at the appropriate time. That was my only concern at this point. I'm sure we'll be talking again in a few minutes. Thanks.
The next item on the agenda is consideration of draft amendments to the Commission's regulations governing the handling of Sunshine Ordinance Task Force referrals. Mr. St. Croix, would you like to introduce this matter?
As the Commission knows, we've been trying to effect new regulations to somewhat expedite the process for handling sunshine complaints, and having gone back and forth with proposals and advice from the task force, the amount of time is that we have not actually completed any work on this is grown sort of lengthy. And in view of the fact that the task force has not met recently, and we're not sure when it's going to meet again, the staff feels that time is more of the essence, and that we should go ahead and move these forward so we can move some cases that are stalled here. Having said that, the sections are broken down into 6 sets of decision points that I think are, sorry, actually 6. There are multiple decision points under 1 through 4 and 1 through 5, and then a single at 6. So the staff memo and the proposed changes are in front of you. These were posted as part of the agenda on the website since last Thursday, so I'm not sure why anyone would think that they didn't have access to them. But and so I propose that we would do discuss all of the decision points 1, and then vote on those, have a discussion on decision points 2, vote on those, and so on.
Okay, I think that sounds reasonable. And just as a further preface to this, this was a result of what I thought was a productive meeting with the task force in April, where we hashed out the structure of this document, and I think this document is certainly meant to reflect what came out of those discussions. So the notion that the task force hasn't had input into this, I think is inaccurate. I think the task force at the time, which was a very experienced group, was an equal participant in putting this together, and I certainly appreciate the efforts of the task force in that regard, and see many familiar faces from that meeting, and I'm glad you're here. Like Mr. St. Croix said, there are a number of decision points, and I do think it makes sense to handle them in 6 segments. I appreciate the concern that with 36 decision points, we're not going to be able to handle them one at a time. I do have some comments on the first section. Mr. Studley.
I have 2 questions that may cut across the decision points, and it would be helpful to me if I could ask them now, because they may help me understand the sweep of them, and then one quick comment about the timing. This is a very practical implementation kind of question, but I think it slices across a number of these. If an elected official or department head and also an employee who is not a department head are respondents in a matter, it would just help me to know whether we would have 2 procedures using the 2 different methodologies, or whether they would be combined and which process would apply. So my own practical thought was that because the burden is different, we would have 2 proceedings. But I just wanted, before I assumed that, to ask whether we had thought about that.
So you're
otherwise I would.
Are you talking about 2 different individuals, one of whom is a department head, for example, and one of whom is a public employee?
Exactly.
My understanding is that it would be different proceedings. Is that right, Mr. Chatfield, Ms. Argumento?
Correct. The way they're drafted now, yes, because the standard would be different for an elected official or department head, they would be separated into 2 different proceedings.
And procedurally, did I read it is there anything other than the burden issue, the presumption, that is different between the 2 sets of procedures?
Not significantly, no. I mean, the hearing will most likely follow in the same way.
They're both public. The standard, the evidentiary issues, the procedural issues seem to me to be the same, but I just wasn't able to line them up to be sure of that.
Yeah, I think the role of the commission staff is different.
That is true. Apart from the
Yes, yeah,
procedural
yeah,
aspect of the
I
hearing,
understand
yes,
that,
the
yeah.
role of both the executive director and staff would be very
Right.
different.
The comment I just wanted to add at the outset was about timing. I agree with you that we've had very helpful conversations with the task force through 2 cycles of review. I wish we had been able to get comments on this written draft as we get closer and closer, we think, to something that resolves a number of these issues. But am I correct that we can go back and amend if after the task force comes together again and is able to begin meeting, if they reviewed it and had suggestions, we could at that time take them?
That is my understanding, yes.
So for my part, it seems that in the balance between waiting even further for a process that everyone is eager to have move forward so that we can address these matters, that it would be better to act on these and then accept any comment, amplification, clarification when the task force is able to give it. At that point, we might have some experience under our belt as well to see how they operate, but at least we would be able to get going and address some of these. And I think that is a major point that the task force has been making to us, and it's something that I, for one, would appreciate the ability to feel that we had. We're establishing some momentum, taking the good suggestions that we've had as we've refined and seen each other's perspectives and go forward, recognizing that they might later have additional thoughts when they're able to operate. Thank you.
Any other comments from the commissioners on that? General comments? I think those are good points, and certainly we would be open to amending this like we are with anything that isn't working as intended. For decision point 1-1, I had no particular problem with that section. Did anybody have any amendments to 1-1?
Are you seeking motions on each one?
No, we're
as a
not. We're not
decision
taking
item?
motions.
Okay,
We'll just
great. Okay.
we'll take a motion
Sorry.
on all of decision point 1. 1-2. I had a question. This is not a criminal matter, right? So the is not guilty of language in M seemed potentially inappropriate. Probably should say something like has not committed.
In mitigating information you're talking?
Exculpatory
Oh, I'm
information.
sorry. I'm sorry. You're correct, it's not criminal, so that language could be changed to reflect that better.
Okay, yeah, so maybe we can change that to something like has not committed the alleged violations. Any other questions? Okay. We'll take public comment on decision point 1-1 and 1-2.
Good evening, Commissioners. I'm Richard Nee. I'm with the Sunshine Ordinance Task Force, which, as you know, right now is dormant. But in decision 1.2, I'd like to, I'm a bit concerned that you're using in paragraph O, public records means records as defined in CPRA 6252E. I would suggest that instead you use as your basis Sunshine Ordinance section 67.24 because it's broader in what it defines as a public record, and as a matter of fact, the Sunshine Ordinance does override certain CPRA exemptions, and I think the ordinance should be the governing authority here. Thank you.
David Pilpel. I would, speaking as an individual, although I am a member of the task force, but I want to make clear that I'm speaking as an individual tonight. I would actually agree with Mr. Nee's comments, although I'm not sure that 67.24 is the correct reference. I think it's 67.20 B or C in the definitions of public information in the ordinance. Also, with respect to item P, referral, this I think could be tightened a bit. Now reads a written document from the task force to the commission initiating a complaint, perhaps tracking better to the language a referral from the task force alleging a violation of the Sunshine Ordinance. There could be any number of other documents from the task force that might initiate a complaint, but aren't necessarily exactly a referral in the manner specified. Just a thought. Thank you.
I'm not exactly responding to decision points 1A and 1B or whatever they are. I just want to make a statement. This draft reverts to much of what the task force found problematical in staff's August 2010 draft, primarily in the nature of the public hearing on task force referrals and the omission of enforcement of supervisor of records orders. Many of the changes reflected in the submitted draft last year ago June have been ignored with no explanation. As, of course, I assumed that the task force was going to review this, but since it's not going to, then what we're going to find is that a group of individuals who have no previous, not only association with these regulations, but experience on the task force, the current group has never heard a complaint. So their ability to deal with this is going to be hampered. And it would have been a lot better if staff had been courteous and explained why they included many provisions that don't belong in this document and which we will now have to talk about on a case-by-case basis. And I am surprised that with only 10 days' notice, when almost no one has a chance to look at this very carefully, that you're going to push this through. Really, you're going to push it through, and what we will end up with is a set of regulations that will reflect Mr. St. Croix's unabated hostility to the task force and its work. Thank you.
Peter Warfield, here. Item 3 is listed on the agenda as consideration of draft amendments to the Commission's regulations governing the handling of complaints alleging violations of the Sunshine Ordinance and referrals of such complaints from the Sunshine Ordinance Task Force. For those who have not read the paper copy of their own agenda, there is no indication on the paper copy that there are any documents whatsoever related to this agenda. And in fact, I have in my chair next to me 3 documents that might be related to this. And when you start talking about this section and that section, decision points, are you talking about Ethics Commission regulations for complaints alleging violations of the Sunshine Ordinance? None of those words are in the agenda. Or are you referring to another document called Attachment B, and it says Ethics Commission regulations for investigations and enforcement proceedings? Is that what you're talking about? Or, my goodness, is it this memo regarding regulations regarding enforcement of Sunshine Ordinance complaints? it would be very helpful to everybody if you not only listed on the written agenda what the documents are that are in question, but which ones you're talking about, so that out of the dozens of pages, we can find exactly what's being discussed. And I'm sorry, but it's not easy when you leave all that stuff to people at the last minute digging around through their documents. Now, with respect to public records, one of the difficulties that I've found routinely, and I'm not sure there is a solution that's easy, certainly, and that is that the Sunshine Ordinance repeatedly refers in various parts to information. And the best example I can imagine is, for example, the Library Commission typically meets and has for many years on the first and third Thursday of the month, with a few small exceptions in the summer and in the winter. They typically set their schedule of meetings in December for the following year. If somebody comes at the end of November and says, when is the January meeting of the Library Commission, there may not be any document that tells when it's going to be. But the practice, and these people may want to make some plans, there may be very clear information, perhaps in the heads of everybody who's working on it and in the memory of people. They always skip the 1st January, but they go on with the 2nd January, for example, or they skip the 2nd December meeting, but hold the 1st January meeting. That, to me, seems to be information that isn't necessarily yet written on a public record, and it could be stated that that's likely to be passed. That's something that I think ought to be considered, and also the references to information in the Sunshine Ordinance. Thank you.
I'd like to reiterate the complaint or the observation of Mr. Warfield, and also the observation of Mr. Nee, because the Sunshine Law 67.24 is far more clear than the public records section is defined in the state law. And I'd like to point out that it says in section 6736 of Sunshine that the ordinance supersedes all other local laws. This is the governing law of official conduct in San Francisco. So if I go to the San Francisco Police Department and I want to look at records of a case that's closed, I shouldn't have any problem from the San Francisco Police Department saying, no, we can't share any of the tape recordings with you, or we can't share any of the evidence that was collected, both audio and video, with you. When in fact, if the case is closed, those are now public records, especially if I want to apply those to Brady law violations against Attorney General Kamala Harris. This stuff is really important. And I'm surprised to see you all looking at me shocked, because, well, this is what you get when you spend, 10 months on Rosmir Karimi railroading him, and you spend 10 days trying to push this thing through. It doesn't give any of us on our side any opportunity, and I excuse myself for miscommunicating the idea, Mr. St. Croix, that I wasn't prepared with the minutes that you prepared, the documents you prepared for this meeting. I was referring, I wasn't able to read any of the minutes that you guys approved of the Mir Karimi hearings previous to your approval of those minutes. 1, 2, 3, 4, 5, 6, I don't know, what was it, 10, 12? Anyway, thank you.
Hope Johnson, I have two, well, first I want to say that it would be, I understand it's been a long time that these have been, since these have been reviewed, but it would be nice if the task force cannot discuss these with each other without having a meeting, because otherwise it's an illegal meeting. So I would still urge you to wait for them to have at least one meeting so that they can have at least one legal conversation about it. But in light of your not doing that, if you're not going to do that, my two comments on these are in section 2, item G, complaint. A task force referral, it's a little bit of a mischaracterization to call that a complaint. It's a request for enforcement or a request for a show cause hearing, not a complaint. It was a complaint when it was brought to the task force. That section also does not provide, I believe someone may have already mentioned this, but I'll say it again in case, it does not provide for somebody who went to the supervisor of records first. That may come here as well. I'm not sure how you want to handle those situations, if they might be considered a new complaint if brought here, but if the supervisor of records has already had some investigation, it may just be another show cause. And then in section N of that same section, in item N, the mitigating information, the language that it uses, it says tending to excuse or reduce the culpability of the respondent's conduct. I feel that there needs to be a little bit of explanation or something related to the idea that there may be an order, a referral that's requesting enforcement, and that enforcement that they request might be production of documents, in which case there is no excuse or culpability in state or local law. It's associated with whether or not there's an exemption for the documents, and because they're all public records, but you don't have to produce them if they fall under an exemption. It's not an excuse, or there's nothing that mitigates that. So if someone, that doesn't seem to capture the idea that some of them people will want just their the records or the information that they wanted, as opposed to a fine or finding some allegation legitimate.
I have a quick question for you, if you don't mind, may I? On the supervisor of records reference, is there something that you would suggest be included or changed to address the situation that you were describing?
Well, what's that? I do think there is something in the draft that the prior task force submitted, but and I can look at it and make a suggestion in a minute, but I'm not exactly sure how. My hesitation is I'm not sure how the supervisor of records referral would come to you. 6735. Does the supervisor of records make referrals to the Ethics Commission? Can someone go to them, or would they have to come to the task force? Do you know this answer, David Pilfell?
Mr. Pilfell, why don't can you come up here for a second? I couldn't hear you.
David Pilpel. Determinations of the supervisor of records are not automatically forwarded to the commission nor the task force. Someone may bring allegation of a violation to the task force, which could result in a referral, or they can file a complaint directly with the commission alleging a violation of the ordinance. But supervisor of records determinations do not automatically go anywhere.
But neither do task force. Task force determinations don't automatically go anywhere.
Correct, but they can send a referral here.
So the supervisor of records, once they make a determination, if someone filed a complaint here again, the person would have to go through the whole investigation again?
I think I understand your point, Ms. Johnson.
I may be able to look at it and formulate something and say it again at a later time.
Right. And I realize that, Mr. Chair and Ms. Johnson, that I may be opening a Pandora's box to do something more than we can handle tonight. It could be that there are some elements that could be added later, but that we could move the things that we are doing that as to which the commission thinks are acceptable after hearing public comment, and then return to add specific situations that may not be addressed here. So I appreciate the input, but it does remind me that some of these might be more complicated than we can handle in this format. And wouldn't do violence to our acting on the ones that are before us that we are eager to have. Excuse me, Mr.
That's quite all right. Are you done?
Yes, thank you.
Okay. Patrick Manette Shaw, I take exception on this first decision point with definition section 2, M as in Mike, and N as in no, and P as in Patrick. Regarding M and N, both exculpatory information and mitigating information suggests to people of ordinary and average intelligence that you're fishing for some way to let the respondent off the hook through an investigation of some sort. When sunshine cases are referred to for enforcement, you are not supposed to be conducting a brand new investigation. Even your new process here that you haven't adopted yet says that it's up to the respondent to meet the burden of proof that they did not violate the Sunshine Ordinance, presumably by citing a specific citation in state or local law that permits them to have violated the Sunshine at the time that they did so. So I would suggest that you take M and N out completely. Your role is not to help the respondent mitigate or exculpate their behaviors at another quasi-judicial body. And I believe I'm correct, maybe Mr. Grossman will correct me if I'm wrong, the Sunshine Task Force is a quasi-judicial body. They've already conducted their investigation. You shouldn't be redoing their work. As for 2P as in Patrick, the definition here, it reads, referral means a written document from the task force to the commission initiating an ethics commission complaint. That's not what the process is. When the task force forwards you a matter for enforcement, it's for enforcement of a complaint previously heard at the task force. It is not initiating a brand new complaint with the Ethics Commission. So you need to rework the wording of 2-Patrick before you adopt it.
Good evening, Bruce Wolf. To Commissioner Studley's question, 2 points. We went over this in the April meeting, and so it was very clear in the ordinance that there are 2 pathways that the task force can ask for enforcement. One is through the willful failure official misconduct path, and the other path is it can choose any other appropriate entity, city, agency, or what have you, department to provide enforcement. But to your additional question with regards to the supervisor of records, in 6721D, it states that if the custodian refuses or fails to comply, the supervisor of records shall notify the district attorney or the attorney general, who shall take whatever measures he or she deems necessary and appropriate to ensure compliance with the provisions of this ordinance. It's a shall. It's specifically only, and this is regards to public records disclosure. So that is in the ordinance and has been in the ordinance. But the task force, that's for the supervisor records. For the task force, it has the additional ability to take it to any other body that would be appropriate. Thank you.
David Pilpel, I already spoke. I just wanted to point out there are 2 items L in Section 2 definitions, so perhaps those can be relettered. Thanks.
Good
Good
catch.
for you. Embarrassing.
Hi, I'm Allison Washburn. I'm one of the the League of Women Voters holdover on the task force and attended the April joint meeting with you. And I'd like to reiterate something that Patrick said. I also take issue with P and the characterization of our referrals. And in reviewing this document last evening, what stuck out for me most of all was the absence of any clear idea about what would happen with our referrals to you for enforcement. A lot of the matters that come before us, yes, there may be violations of the ordinance. For whatever reason, they may be willful or just, egregious or non-egregious. But what the member of the public wants and what we want to see the member of the public obtain are public records. And so we become very frustrated during the process where we find a violation, we issue an order of determination to produce the records. The matter is sent to the committee that I've chaired, Compliance and Amendments, and very often the respondent doesn't show up at all. And then we send the matter back to the full task force for some determination about what to do. Again, the respondent doesn't show up. We often don't have a clear idea about why the record wasn't produced. So, our recourse has been to send the matter to you for enforcement, for production of the record. And so there's a lot in here about, yes, having a show cause hearing and looking for reasons why there was a violation or not, and exculpatory information and mitigating information. But the bottom line for the complainant and for us is that the public records that the public has every right to obtain are produced. And so I think the regulation should be clear in addressing this most usual, I would say, type of matter that we would send to you, where we just want your help to get this information, regardless of why it wasn't produced, because often we don't know. Thank you.
So how would we change it to do that?
Okay. So I think there were some good points raised by the public. I think we should, let's take them in chronological order rather than order of presentation. Section G, the complaint. I mean, I understand the concern. We're not saying that a task force referral is meant to be to suggest that there is no that this is just merely a complaint as if it were initiated by the commission. However, I do have some concern because I know that complaint is relied upon throughout the document. So if we change the definition, I think we could wreak some unintended havoc on the rest of the document. And substantively, I don't think it makes a difference there. When we get to referral, we can I think deal with it in that section. The other issue, the supervisor of records, staff or Mr. Shen, do you have any thoughts on that?
I believe someone did reference at some point the provision that seems to principally address what the supervisor of records does, and that is 6721D. And I don't see, and they did when they described basically what that provision does, I don't see anything in the regulation that precludes the supervisor of records from carrying out what the Sunshine Ordinance provides. It doesn't really address, the regulations doesn't address the supervisor of records, doesn't attempt to limit what the supervisor of records would do, so it doesn't interfere with that provision of the Sunshine Ordinance. I don't know if staff has any different view on it.
Right, and so if the supervisor of records does what they're mandated to do, which is send it to the district attorney or attorney general, and they do nothing, And that person, the complainant, can come to us under 6735D, I think it is, if they wait the 40 days. So they can do that. It can fall under something that's either directly initiated with us by the complainant. The supervisor records, I have not found in the Sunshine Ordinance, I could be wrong, something that says they can send it over here, like the task force has in 6730C. So I think it's a little different, but somebody has the right under 6735D to come to us as long as they wait that 40-day provision that's in there.
Okay, so if a referral is made from the supervisor of records to the district attorney, for example, and nothing happens for 40 days, then the complainant can bring a case directly to us.
Correct.
If the supervisor of records does not make a referral, then what? Then the complainant has to come directly to us?
If the supervisor of records makes no referral to the district attorney, you mean?
Right.
Well, they have to. It says they have to. But if say they don't, I mean, as Andrew said, there's nothing that stops the supervisor of records from referring it directly to us, and I think that would fall under a written document submitted directly to the Ethics Commission for us to initiate it. So there's certainly nothing that would limit it. It's not my recollection that they ever have sent a referral, but there's certainly nothing that would stop it either.
Okay. Mr. Shen?
Yeah, and also I realize that some of you may not have the actual provision in front of you, and I can pass up my copy if that'd be helpful.
That likely would be helpful. Okay, I mean, what is staff's view on whether we should include this supervisor of records office in the definition of complaint?
It's perfectly fine. I mean, we would take the referral, so there'd be no issue including that in there. Again, I don't know, I think G might be worded broadly enough where it says, or a written document submitted directly to the Ethics Commission to actually initiate the complaint if it came from the supervisor of records. But I don't think there's any specific issue with adding language in that identifies that office.
Right, but well, I guess the substantive question then becomes, are we going to give it the same presumption that we're going to give a Sunshine Ordinance task force finding of
I think we'd have
violation?
to, because that provision in 6721D mirrors pretty closely to the task force in E.
Right, okay.
When you start adding, specifics of who can take an action, you kind of also need to suggest the list is not exhaustive, so that if you put some things on there and not others, there's not a presumption in the future that if it's not there.
Okay, but we are giving special presumption to a finding by the task force of a violation. So I think we have to be very specific about who we're talking about there. And I think the question is whether we add the custodian of records finding to that.
Just to add one other thing, and I apologize if we're getting a little bit too lost in details, but the supervisor of records provision is essentially, I think, setting forth an option, I think, for a person who has a question about the availability of a public record, separate from the task force, separate from the Ethics Commission. Certainly, the Ethics Commission can try to incorporate the supervisor of records into the current enforcement scheme, but I would just echo, I think, Garrett's observation that there has been no history of the supervisor of records referring matters to the Ethics Commission. It has been much more so, at least in the past few years, matters coming from the task force, but not necessarily a limiting factor.
Any views from the commissioners on this? I mean, I am sympathetic to that, and I'm also wary of adding things in one place without fully vetting the consequences of doing so in the document. And if we haven't had any referrals, it seems like we would be potentially legislating an issue that might not occur and given us no reason to expect to occur. Commissioner Sedley?
I was just going to suggest that if I understand where you're headed, that we not make changes now because we'd have to follow through all of the implications, but that we create a list of issues that we want to talk to the Sunshine Task Force about when they are able to meet again, and see whether they, just because something hasn't happened doesn't mean that it won't or that we shouldn't have a home for it. But I think it's more important that we get as far as we can with this tonight and flag that later. It doesn't stop anybody from doing anything that they want to do. It doesn't foreclose any opportunity to bring something to us, either from the task force or they came through that procedure. So maybe we should put it on what my organization calls a bike rack and understand that we want to check that through again, ideally when the task force is able to consult with us on it, but that we not try and do something now in one place that might be more complicated than we realize. That would be my thought.
I think that's a good suggestion, particularly on an issue that potentially far-reaching. So can somebody, Garrett, can you take down the list for the bike rack?
I already started it.
Thank you. The next issue that was raised by the public, M and O being necessary. I think we should include them. I mean, we're not suggesting that there is exculpatory information or that mitigating information exists, but I think defining it is helpful because it is used subsequently. The lettering should be fixed. Current letter O, public records. So what does staff and the city attorney think of changing the reference to a Sunshine Ordinance reference rather than a CPRA reference?
I think that probably that falls on the, put it on the list to look at later so that we can do some background comparison before we make a change.
Okay. Anybody have a different view from the staff or city attorney?
I mean, the definition we just mirrored what was in 6720B about what public information is. The member of the public is correct, 6720 is a little broader, and it does define what records should be disclosed. I don't know that would be a necessary problem, but again, it's something that we could address later if you want.
Mr. Shen, anything?
I don't really have much more to add. I'm not sure as a practical matter whether using the term public information versus public records will be different in terms of how the commission would address an actual complaint that comes before it. And I would just note that the Sunshine Ordinance does use both terms as well. It does refer to records and information somewhat interchangeably as far as I can tell. It's not entirely internally consistent.
6720B of the ordinance directly mirror 6252E?
It incorporates it.
It's actually,
and I believe you have it in the page that I handed out, in case you need a copy.
Right. Well, I have 67.
It actually is 6724 that defines what records must be disclosed. 6720B just incorporates what 6720, or sorry, the state law into what public information is.
So I need 6724.
24.
That's what Garrett's saying is not.
I don't know. I mean, just saying 6724 actually, it tells you what, you know, I think it was.
Okay. Let's put that on the list for now. That is a fairly important issue, though, I think. We're defining what the public records are. I think we need to be confident we have that right.
Through the chair, a quick additional point on L, the misnumbered L. I'll be really brief, Commissioner.
Okay, really brief.
Okay, so right at the tail end of the sentence, it says that a willful violation of Sunshine Ordinance by an elected official or department head occurred. I think you are continuing to drop the key phrase of 6734, that it's elected official, department head, or city managerial employees, and you should not drop the term managerial either here or throughout the rest of the proposed recommendation.
Okay. Referral means a written document from the task force to the commission initiating an ethics commission complaint. I think that definition can be modified to reflect that the referral is a document from the task force finding a violation of the Sunshine Ordinance.
Earlier, you said alleging a violation?
I mean, they found a violation. Whether we agree is a different story, but I think a referral indicates, I mean, we wouldn't consider in a show cause hearing a referral that did not find a violation. So I think we need to make clear that there is, the task force has found a violation for us to treat this with the show cause procedure.
You don't have one.
Yeah. Okay, so then the last thing on this issue is what Mr. Minette Shaw just raised, the department head issue. Does staff have a view on that?
Yeah, one of the things that came out of the last meeting was that 6734 omits managerial city employee from the actual enforcement part of it. It mentions it and then drops it. So that was one of the things that came out, that we would only do willful violations against an elected official department head, and then all other employees would fall under the other provisions.
One way to frame it, we don't have a definition of department head. Is that clear under city law, or do we need one, or to refer to the clear city definition of department head? It's a slightly simpler question than the one you just raised, which is interpretive.
To be honest, I don't know if staff really even thought about having to define a department head, because it does seem relatively clear, but we certainly could add a definition if it was.
Yeah. I mean, if
clearer.
If in trying to figure out who is a department head, there's a clear place to go in city personnel law, then we don't need one. I just would like us to have addressed that. Okay, thank you.
Okay. You know, I have some concern about the 6724 issue. Do you have it there?
Yeah.
Mr. Sheffield, and can you read it for the record?
Wait, 6734?
20, whatever it is that you're saying has this definition of
34
public information.
Oh, 24, yeah. Well,
where is the definition of public records?
It's a list of things that are public, basically. So it's not one simple definition. It's
does it begin?
Right. So 6720B defines what a public information is and references the government code. But 6724 provides a list of documents that must be disclosed. So it depends on how you want to deal with that. So if you want to define a public record as all of the things listed in 6724, I think that would be okay. Or
look, I appreciate. Okay, look, we have public comment. There's an opportunity to speak. We can't take public comment while we're doing this deliberation.
But you do want to do the right thing.
Mr. Grossman,
I just mentioned it.
Thank you.
I've got the statute.
The ethical thing.
Like Sunshine Task Force meetings.
Okay. So the issue is, do you
no, I was just going to see if you wanted to look at 6724, so you have some idea about what
yeah,
it's doing.
I would like to. Do we have it? Can we put it on the overhead so the rest of the commissioners can see it?
Too small. Oh, God.
I am disappointed that I left my, my ordinance at the office. Okay, well, actually, there it is.
That's the beginning of it. And then after we get to B, little 2.
Yeah, that might be good.
Goes over
Thank
to
you.
the next page. It covers personal information. Goes through all those lists up to 7, and then it goes to law enforcement information that's particularly.
It's a long list. I think we are familiar with it and have read it many times. What we're trying to find is what the right source of law is to refer to. We know that the list is there. It's which is the right section to create that umbrella.
6720B is the definition. So if you want to use that as the definition, then that's certainly fine. I don't think staff has any objection to that.
Okay.
What the other public comment was, 6724 actually specifically outlines documents that must be disclosed. So if you'd rather tie that into the definition, that would be fine too.
Okay. You know, one thing I don't quite understand, it appears to me that the 6720B is arguably narrower than what we have. It has an exclusion for what public information is not, which I'm not sure is contained in 6252. I'm not sure we want to make what we've got narrower than what is already in the definition. It's potentially broader in that it defines it as in documentary form or oral communication, but I presume that CPRA 6252 well, actually, 6252 may not cover oral communication, does it? And as a look, I'm sorry, I'm going to have to ask. Again, we appreciate your participation. Obviously, you can hear that we're taking seriously what you guys are saying, and we cannot proceed with random outbursts. And we're going to ask you to leave if there is a random outburst. Thank you.
I don't know offhand if that is included in the government or in the state provision or not. So I could look at that if you want. But if you would prefer to have a very specific guideline as to what would be considered public records, then maybe 6724 would be the way you want to define it, because it actually lists exactly what the city can.
I mean, I think we're better off with something like 6720B or what is already in there. I think you want a general definition. Do the commissioners have any? Commissioner Rennie?
Chairman, isn't our desire to have the definition of public records to be as broad as possible under the pertinent statute? Isn't that what our definition is intended to be, not a limiting definition, but a definition that says if 67.24 is broader than what might be covered under the 6252E, why not insert language, say N/or, good lawyer's way of approaching it, N/or the 67.24 definition, and when it comes time to determining whether or not the task force is correct that there's been a violation, they presumably will identify what section they're relying on in their determination.
So your proposal is to include 6724 basically as an or. If it's either or, then it's a public record. Mr. Sheffield, sounds like you're...
I don't have any opposition. I'm sure there's no opposition to that. I mean, we all agree. I think we agree with Commissioner Rennie that the idea is to make it as broad as possible. So if it encompasses both, language of both, I think that would be fine.
I think that's a reasonable proposal. Any objection from the commissioners? Okay, so public records, I think, should be amended to add or 67.24 after Public Records Act, obviously with the correct statutory language. Okay, is there a motion to adopt as amended the definitions and language in decision point 1?
So moved.
Second. All in favor? Aye.
Aye.
Opposed?
Oh, do we have to take?
What is that?
We already had public.
We already had public comment. Opposed? Hearing none, that motion passes. The next issue is decision point 2. I had a few proposed revisions here as well. Under 2-1A, this may seem nitpicky, but I think it might clarify issues a little bit. Under B, I think it should read willful violations of city officers and city employees other than elected officials and department heads. Is that accurate? Because we have the and city employees at the end currently, and I found that confusing.
Could you restate what you would change it to? This is A2?
Yes, this is A2 little b. You know what? Actually, probably a better way to do that would be to put the other than elected officials and department heads in parentheses. I just want to make it clear that we're talking about different sets of individuals.
I found myself all the way through this understanding, I think, the genesis of why A and C are separate, but I think down the road, people trying to understand what we're talking about will wonder why non-willful violations by is not followed by 4 entries, but in fact is separated into 2 different categories. I think it makes something that's already complicated harder to track. I mean, there's history about why they're treated separately, but once you get to this point, we will conduct a show cause hearing on any referral from, I mean, this language happens over and over again, and it's B, willful violations by these particular people, and non-willful violations by 4 categories of people. And I just wonder whether it's adding clarity to leave it, being more clear to leave it this way, or would put all of the non-willful violations together, because that's, otherwise you try and find out, well, what's different about those 2 kinds.
Well,
it's a drafting question that would be a search and replace, and I don't want to do it if it loses something or makes it harder going forward. But if it's just an artifact of how we got here.
I think it was intended to provide clarity, ironically, because we didn't want there to be ambiguity about what we were going to take up and what we were not. And as you'll recall, there was a lot of discussion about what we could and couldn't take, and so we wanted to make it clear that we would take non-willful violations by elected officials and department heads. And we were concerned that if we did not specify that, there might be ambiguity because of...
I'm going to specify it. No, the language I would end up with would be, will conduct a show cause hearing on any referral from the task force alleging, bear with me, A, willful violations by city officers, close paren, and city employees, and B, non-willful violations by city officers, employees, elected officials, and department heads. Or reverse it if you think it should be elected officials.
Oh, yeah, that's good. I think that is good.
Because otherwise, we know how we got to this set of questions, but otherwise people who pick it up for the first time will say, what's the difference between those two expectations? Why are they separate? And we can separate them when there's a consequence that's different, but I think it tangles you up as it currently stands.
Commissioner Rennie?
I agree with Commissioner Studley that to combine A and C into one A, make it A, and I think
Or B. I was just putting willful first because it's more severe.
You would do willful first? Okay,
just because willful is a higher order of
But I would make that paragraph, whatever is now A and C, to read non-willful violations by elected officials, department heads, city officers, and employees, and then, which gets them all, and then say willful violations by city officers, and I agree with you, it's confusing, and your paren probably takes care of it, other than elected officials and department heads paren, and city employees. Now, I might, rather than put a paren, I might say willful violations by city officers and city employees other than elected officials and department heads.
That's what I had originally.
Yeah.
But I think it's 6F dozen.
Yeah.
So either way.
Yeah. And during public comment, I'd be interested to hear if anybody thinks that we're missing something, that we would lose something by merging those. I think it would make it easier for people to understand willful, and these folks non-willful in all of these categories.
Agree. Okay. 2-1B.
I have a.
You had another.
Are you making a comment on? Are you finished with A?
I was, but.
Okay. And you're going to B. I have some other comments. But go ahead.
Do you want to? Well, let's address all of them in A first. So, Commissioner Rennie, if you've got one for A.
Well, I have a comment about the heading. I don't quite understand the use of the word "made" in the second line.
Second line of.
Alleging violation of the Sunshine Ordinance made by, seems to me made is grammatically incorrect. It's a violation of the Sunshine Ordinance by any city officer or employee.
I'm sorry.
Can you say again where you were?
Yeah, where are you?
At the top, referrals from the heading of it. Referrals from the Sunshine Ordinance Task Force alleging violations of the Sunshine Ordinance made by, it's a violation by.
It's the heading in the actual regulation draft.
If you look in the draft of the.
On page 4.
May I ask a question for information only? I'm curious which document we're referring to.
Yeah, we're trying to figure that out too. I think
I've got three documents.
We're looking at the draft, which I think is Exhibit A. Page 4.
It doesn't say Exhibit A, it's just this one here?
Yes.
Thank you.
Could you read the title?
Referrals from the Sunshine Ordinance Task Force alleging violations of the Sunshine Ordinance made by any city officer or city employee other than an elected official or department head. Is that what you're referring to?
Yeah, it's just a made, that the word made in there is grammatically, I don't think, correct.
It's unnecessary.
Okay, I think that's probably correct. So we would propose striking made. That's good. Any other comments on 2-1A? (2-1B). My only suggestion would be that we provide for the possibility that we could set a special meeting. I don't think it necessarily has to be at the next regular Ethics Commission meeting, and I would want to give us the flexibility to specially set something.
Would you just prefer the next, would you want to just say regular or special? I'm not sure how you want to.
Yeah, that's what I was thinking, regular or special. Or actually at a regular or special.
Were we intending to commit ourselves to a time horizon?
We were.
Or is the outside of the time, the overall time for getting to resolution sufficient to compel us to keep moving?
I don't know.
I can help, hopefully. One of the other issues that came out of the last meeting was that we handle these matters quickly so that people get these records fast. So that the whole idea was that we get it at the next meeting that we have that's regularly scheduled, providing that we can do it legally under the agenda requirements. There's certainly no issue if you wanted to set a special meeting for it, but I think the whole idea was to say we are going to do it at the next time we meet. So maybe putting the language of a meeting might remove that.
Okay, right.
Or a special meeting within X days of receiving it.
You could
I
just
mean,
change, sorry,
Yeah, go ahead.
change the word at to the word by.
I mean, we could say at the next ethics. No.
I'm concerned about a situation in which we get the referral 2 days before a meeting, we can't even appropriately notice it in that time frame, and we don't want to, so we can't start with the hard case, we can't even bring it before us at
It
the.
provides for that.
Well, that's,
Yeah.
Provided it can be scheduled, okay.
But
we could have, say, our docket is full, and we want to look at it a week later than our regularly scheduled meeting. The by would not allow for that.
Right.
You're right, I forgot to read further, sorry.
Would you want to put a line that says the commission may schedule a special meeting to hear this matter, or something along that line, so that it gives you the opportunity to actually schedule a meeting to hear these independently of the next meeting?
That was my thought. I'm wondering whether it's worth it. Commissioner Rennie?
I had, when I read that, it struck me that the way it's presently structured, it says a show cause hearing, but then when you read, it says at the meeting, the commission can hear it, or we can appoint a hearing officer or one of the commissioners to hear it, to hear the show cause hearing, so that I guess I had sort of thought maybe the orderly way to do it is that when a referral, it will be placed on the calendar at the next regular meeting or a special meeting as a matter to be then set for a hearing, either before the full commission at its next hearing, or a special hearing, or before a hearing officer who shall report back to the commission at the next scheduled meeting. So that it would be, clearly it'd be a month-and-a-half process probably, but that, I think, certainly considering the nature of what you're contemplating, seems to be the orderly way to do it.
Well, just one more thought. It would give.
Studley?
I think we should allow the option of having the hearing immediately at the next scheduled meeting. We don't want to preclude ourselves from doing that when that's feasible, but the chair in scheduling, it may be that it's not scheduled the hearing, but schedule the matter for hearing or just, allocation or, assign decision about how to assign it so that it comes up. If that's what it is, I think it probably would be fine to have it come up to either say we're going to hear it now, we're going to hear it at the next meeting, we're going to designate 1 or 3 commissioners or a hearing officer to hear it in between, or we're going to have a special meeting.
Can I make a suggestion?
Yeah.
Yes.
If you change the words next regular to earliest practicable, it would read, shall schedule a show cause hearing on the matter at the earliest practicable Ethics Commission meeting.
But would that preclude the possibility that Commissioner Rennie reminds us of, that it may be handled in some other way?
No.
At a special meeting or with it? That I like the idea of trying to see if we could get them to us for either hearing or determination of how we will proceed quickly. I think we might feel choked if we had to have the hearing at the very next meeting, which precludes these other possibilities for adjudication.
I think one concern with sort of leaving it open is that you're asking the parties to appear, and if we didn't decide until the meeting that we were going to actually hear it or defer it, I think that would be somewhat inconvenient.
Mm-hmm. That was my concern in thinking it's a two-step process.
Okay.
Is that it comes before us and we decide either the full commission's going to hear it or we're going to have a hearing officer who will report back to us at a specific time. But that would then give an opportunity to give notice to the respondent and the Sunshine Ordinance Task Force or whoever the complainant is at when the hearing is going to be and when they've got to present whatever testimony or evidence they want to present.
Yeah. I think procedurally that makes a lot of sense. What I'm trying to balance in my mind is the need for speed and for procedural propriety, because I agree with you, Mr. Rennie, that would be procedurally how I'd want to do it. I'm just worried that if let's say our next meeting is 3 weeks away, and then we meet then just to schedule, and then so there are certainly competing concerns.
Are you going to take public comment on this item?
Yes.
Okay, thank you.
We could, it's the balance between, the difference between what we require ourselves to do and what we allow ourselves to do. If we had 3 weeks and the parties were ready and wanted to go forward and the chair thought that this was one the full commission ought to hear and the docket allowed it, then we could do more than was required. So if this said shall be on the agenda for the commission meeting, but we happened to get it 3 weeks out and everybody was prepared to go forward, it wouldn't stop us from doing that. But it may be that scheduling a hearing at the next regular meeting is unmanageable, not just for us, but for the parties.
So what about Mr. St. Croix's proposed language? What is going on? What is that?
I think it's too mushy.
Oh, is that the...
It's a telephone call that's coming in on the telephone that sits here.
San Jose person?
Sorry.
Is there a picture of a telephone? And other duties as assigned.
That's another solution.
I'm a little concerned that Mr. St. Croix's suggestion is too flexible.
It's too flexible. And I'm sorry, your proposal, was there a competing proposal other than Mr. St. Croix's as to what language should be used to reflect the idea that we need some
See
flexibility?
whether Commissioner Rennie has one first. Did you have one?
Pardon me?
Did you have a proposal as to how to modify the language specifically to address the situation you raised?
Well, the language I had, because I was going through the two-step procedure, was essentially this: scheduling a show cause hearing after receipt of a task force referral. The commission shall place the matter on the calendar for the next regular Ethics Commission meeting, provided that such can be scheduled pursuant to the agenda and notice requirement as set forth in Sunshine Ordinance 67.7 and the Brown Act. At that meeting, the matter will be set for a show cause hearing as provided in Section 2 below, Roman numeral 2 below.
Okay. Okay. Well, we'll. I think that's a good suggestion. We may need some tweaking. I'm trying to figure out how to address both of the competing concerns. Any comments to 2-1B? What about 2-2A? (2-2B). I'm sorry, 2-2, right. 2-2A or 2-2B. (2-2C).
I have a question. Why is 2-C there? I don't understand why it's even necessary.
Commissioner Studley?
Similar question, or in the other provision, there's an affirmative statement of the prosecutorial role or who shall bring forward evidence. If we have a need to say who will do that or how that will be handled, that would be fine either in addition to this or instead of this. But it seems odd, you know.
Yeah, this is also a vestige of trying to differentiate between how it will happen going forward and how it's happened in the past, because one concern was the role of the executive director in these matters, and frankly, the burden and the
right.
You know,
it'll just
and
look bizarre to people a few years from now. If we need to say something about who shall have prosecutorial responsibility, then I'm all for saying that here. If there are a variety of people who could do it, depending on how we move it forward, then it doesn't need to say anything. That is a true statement, but I agree with Commissioner Rennie that it doesn't need to be said here.
Okay, any other comments on 2-2C? 2-2D? I had some concern here about the use of a representative, a non-lawyer representative. I mean, maybe that's common in these sorts of proceedings, but it seemed odd. It also seemed odd that the representative could be a member of the task force. I have no problem with the task force having a role at this hearing. One possibility is for the task force, if it chooses, to come and explain to us the decision that was made. But to have the task force member represent one of the parties that it adjudicated seems unusual to me, and something that I'm presently not in favor of.
If we said nothing and people could have, somebody coming before us could have a representative, couldn't they pick anyone they wanted unless there were a requirement that it be, council, and I don't think that's necessary. Couldn't they pick anybody they wanted unless we precluded task force members from being able to do it?
Well, I guess, for example, if in the hearing in front of the board that's going to go forward on this Mirkarimi matter, if one of us were to appear on behalf of one of the parties, I think it would be a problem. And so to have the task force be representing a party that they adjudicated seems like a conflict of interest and would not reflect well publicly.
Then in that case, we would change, if we agreed with you, we would change it to say that they could not, because otherwise they could choose anybody they wanted.
Yeah, I think you'd have to say that.
And you're suggesting building in a role where the task force could decide whether, as task force, it wanted to speak to us about what it had found.
Right. I'm also not sure we need, I can imagine a situation where you need a designated representative. But as a rule, it seems like wouldn't we rather hear from the party if we could? I'm certainly, I don't feel strongly about the representative issue, but it did strike me as odd.
Since we'll have a record and a finding, I'm trying to think what it is that the movant, the person who brought it, would be saying to us. Whether it's technical kinds of things that they should be entitled to pick somebody with more technical knowledge or more comfort speaking to a group or whatever it is than they've got, or whether we do want the authentic, here's why I needed it. I'm literally trying to picture what we would say since we would already have something in front of us.
And maybe this is just my sort of legal hat that doesn't apply in this situation. But for example, an attorney, when he comes to speak, is bound to, if they say they're representing them, we can take what they said and apply it to what the party, that was the party's word. But any individual who just comes in doesn't have that same obligation, typically, that their word represents what the person's word intended. So I don't know, Mr. Shen, if you have a view on that, whether we would need to build into the regulation that a person who appears on behalf of someone else must represent that they can speak for that person, or what sort of caution we might need there.
I don't really have a strong view on that issue. I suppose if there were a party to one of these proceedings and they felt their representative was speaking in a way that they weren't comfortable with or disagreed with, I'm sure that party would speak up.
But what if they weren't there?
Then I suppose that's a consequence of their decision to send a representative and not attend.
So then we should just presume that if someone comes and says, I represent person X, that they have de facto agreed that whatever person X says is going to be, they're going to be held to what person X says.
I think that's really up to the commission's discretion. It's certainly, it's, just speaking with a lawyer hat on, I'm sure most judges don't ask for evidence that a lawyer appearing on behalf of a party actually
well, of course,
is representing
we're bound by the professional rules to
right,
represent
but
the party.
certainly a judge doesn't ask for a copy of a representation agreement before.
Because he doesn't have to, because
they exist.
Because they exist. But just a member of the public.
Well, we presume they exist. It's not that different.
Well, yeah, right. But if it for some reason wasn't correct, then
there's another forum.
There's another forum. But a member of the public who came forth purporting to represent someone, if they didn't have the authority to do so, what would be our recourse?
And I suppose, just speaking practically, what may be likely is that the party may show up at the next Ethics Commission meeting and say that I sent a representative here, or someone showed up at the prior meeting purporting to be my representative, and that was not the case. I didn't receive a notice for whatever reason, and now I'm here to state my case. I suppose that's one practical possibility. I mean, I'm just not sure how likely that would be. But I understand that you're concerned that you don't want people to speak without the proper authorization from the party. I think that's a fair point.
Commissioner Rennie?
Do you think we unduly complicate it if we require if there's a representative rather than the complainant, that he or she come with a written authorization, with a letter saying that by whoever the complainant was, that I've authorized this individual to appear on my behalf?
I think that's a good idea.
I mean, does it complicate? Is it too difficult for that? Get that, do you think?
That strikes me as reasonable, but Commissioner Studley?
If we keep it, I think that is a reasonable addition. I'm trying to think whether we need that provision at all in order to make it possible for the public to pursue their or stand up for the position that they've taken, that they want these records. Since we'll already have something from the task force explaining the more technical side of it, I'd be interested in whether the public thinks that we need this in order to let people run the string of steps that they're entitled to, or whether it would preclude people or somehow chill people's capacity to put the issues before us. If they didn't think so, then we could take the whole thing out and see if there was a problem that might be solved by adding representatives.
Mm-hmm.
Of course, alternatively, we could start doing it and then say, this is a muddle, let's just simplify it. But I think it's easier to add this than subtract it. But I'd personally like to hear whether people who've seen people actually bring these forward think that it's a necessary idea with the amendment that you've talked about or not.
I think that, too, is a good idea. Commissioner Han?
Well, my question is, why wouldn't we expect that the original complainant and respondent be the ones involved? I don't really understand why they would not appear, or why they would need a representative in this matter.
I see two potential issues. One, I could see it helpful if, for example, the complainant felt like they couldn't express it in a way that would be most effective. I think that's one possibility. I think the other possibility is if you have an elected official who may want to send a representative who maybe handled the issue more directly or something of that nature. That's just speculation, but
I'm inclined to go forward with it as it is with Commissioner Rennie's amendment, but I'd like to hear whether others have reaction.
Okay, I am too. Any other comments on 2-2D? How about 2-2E? Commissioner Studley.
The note that I wrote to myself as I read this was, these all, I'm looking at the relevant circumstances. These all sound like bases for finding non-willfulness or non-violation. Are there any factors that could cut the other way? These all sound like they go toward mitigation or minimization, and while those are important and should be included, there's no parallel. It's a one-way ratchet, and I think that is not the right way for us to be drafting these. So whatever the opposite of mitigating, exacerbating, some 25-cent word that we lawyers throw in, aggravating, it just seems unbalanced the way this set is written. I don't have a revision apart from the helpful word that just floated to me, but I think we could come up with one while we talk.
Mr. Chatfield or Ms. Argumedo, was this intended to, what was the intent here in A through D?
Well, with the show cause hearing, the understanding was that it's coming forward with a determination that the violation has already occurred.
Right.
So this person has to try to demonstrate why it didn't or show mitigating factors why it isn't a public record or what have you. You know, that's really why they're in there. You can, you could probably end the sentence with consider all the relative circumstances surrounding the case, period, and just consider what is pertinent to you at that time, be it mitigating and aggravating factors, and not have any list. This list is certainly not meant to be exhaustive anyway. It says not limited to, but it might be simpler for you to just allow yourself to be able to consider everything without having some set.
Yeah, what about if we removed A through D?
Which?
A through D?
A period where there's a comma now? I'd be fine with that.
I had the question when I read those, as saying, are they intended to be essentially affirmative defenses? In other words, that one can say, and when I get to D, for example, whether respondent consulted with city council, relied on the advice of another city officer or city employee, I mean, that probably is a grounds for which it becomes difficult to say that there's been a violation. We might decide that that the advice they got was wrong and that we should issue an order saying that the documents should be produced. But on the other hand, we might say the employee acted in good faith. He went to the city attorney and the city attorney said, you don't need to produce them.
I think we're not trying to eliminate these. These would all be under the heading of what was relevant. They would still be part of the relevant circumstances surrounding the case. The question is whether to enumerate some of them here that we've anticipated as possible defenses. We don't eliminate the explanation or the defense if we don't list it here. The question is it useful to say that that is one of the circumstances that would be appropriate to raise?
And I think you're both right, actually. I don't think we need them, and I don't think it limits the affirmative defense. I think the problem with some of these is that they're not affirmative defenses. I think Commissioner Rennie is right. The only one really that probably would be an affirmative defense is D. The others might be factors in affecting the penalty, but they're not really defenses to the allegation. Commissioner Hand, did you have your? Okay.
They're circumstances, but they're not defenses.
Right.
Well, I don't feel strongly about if we wanted to end it just surrounding the case and eliminate everything beyond. But I do have a different issue.
Okay.
There seems to be a gap. If we decide to refer the show cause hearing to one commission, we don't say what he or she is supposed to do if he or she reaches a conclusion that supports a finding of a violation. I think what's contemplated is that that gets reported to the full commission, and the commission debates whether 3 of the commissioners want to agree with the hearing officer. But we don't have any provision for what happens with the hearing officer's determination.
Unless we change the procedure about 3 commissioners, and if a person gets that responsibility, they hold the hearing and make the determination alone. Well, must we have it come back to the commission?
But that's what I'm saying, that if you have just it contemplates that it could be a hearing officer, not even a commissioner.
Right.
And what does he or she, or what are they supposed to do once they've held the hearing and reached their determination as
You're right.
makes their finding, it has to get reported to the full commission, doesn't it? For action.
I assume that's correct, but I welcome input from staff and city attorney.
To be honest, when this was drafted, I don't think staff really was contemplating that there'd be one person on their own dealing with this. The idea was that one person would be holding the hearing, asking the questions. The commission would not be doing that as a whole, but you would still be doing it in public session at a meeting, and then you would then deliberate as a body. The hearing officer would just be the one procedurally running the matter rather than the commission as a body doing it. That was actually staff's contemplation. It wasn't that we would have a separate matter with only one commissioner present and that one commissioner making a decision. It was always that the full body would deliberate and that the one hearing officer would just be procedurally running the hearing. So if that's not clear, then we certainly should make that clearer.
Yeah, I think we should make that clearer.
Because I thought under the idea of one commissioner or one hearing officer is speed, so that, say, once it gets assigned, hopefully it can get set maybe within a week or so that at the next full commission meeting, a report can be made back to the commission of saying, we've had the hearing, we either think it should be affirmed or whatever, and leave the deliberation as to the penalty side of it to the full commission.
That's interesting. I mean, in some ways, you could have a set, if we wanted to fully utilize that procedure, because it would provide potentially more speed. I mean, one idea would be to have a regular date, and if we wanted to delegate it to one officer, if there are complaints, have them heard on that day, whatever it is, the first Monday of every month, and if there aren't, then that hearing officer doesn't have to appear. If there are, he or she does, holds the hearing, makes a recommendation, and then the matter is heard by the full commission. I mean, that's certainly one possibility.
Well, and not the matter, but the recommendation from that one commissioner comes back with having held the hearing, which would be public,
right,
would then say, I agree with the task force, and here's my recommended penalty for these reasons. And we would have it on our docket, but not have held the hearing.
Right.
Maybe we should delete the language about assigning one of the members for now, and we'll bring it back as a separate agenda item after we have a chance to develop a proposal for a process.
Okay. I think that's.
I just want to clarify. So, do you want me or staff to delete the reference to assigning a hearing officer in all cases, and then we can contemplate that later?
I think that's. Commissioner Sedley, what did you?
No, go ahead.
I think that's fine. I think, Mr. Shen, you're shaking your head?
Oh, no. Oh, I wasn't shaking my head at all. I apologize.
Okay. Yeah, I think we should think more thoroughly about what a one-person procedure would look like if we really want to have a process of delegating it to one individual.
I think we could still, if we wanted, have a person assist the commission and manage it in our presence. I don't know that would require a separate, because we're not then giving over any part of it to somebody else. But I think the idea of bike racking this and thinking through all the steps.
Yeah, was the idea to have a non-commissioner appointed?
It was just leaving it open for you, but there was never any contemplation that you wouldn't be there, I guess, while it was happening.
Right.
So, although your suggestion actually does have some, I think it's a good idea to pursue, but it would be complicated in the moment to try to sort that out. So, if that's something you do want to do, I think we should certainly look at it. But we really did not intend in any way for there ever to be a hearing without the full commission being there. It really was just one person to trying to expedite the process in and of itself.
Right. Okay, well, we'll hear what the public has to say about that. (2-1F). Commissioner Rennie?
Yes, I raised a question about 1B that says the respondent department commission to pay a monetary penalty to the general fund of up to $5,000. I guess the first question I have is what if the department's paying it and it goes to the general fund, what are we just moving dollars from one agency to another? I mean, so, and isn't what the, as I understand what the task force wants, and I think what we want, is that if we find that the documents should have been approved, is a order that the documents be produced, which if they fail to comply with it, I guess they have to go to a court to get some citation. I mean, that's the most we can do, but to order them to produce the records. And if we're going to impose, and we get to willful, maybe it may be different, but if we find that a fine is appropriate and we have the power, I don't know why the fine shouldn't be paid by the individual who's failed to, we find, has failed to comply.
I too have questions about the monetary penalty, in part because I'm not sure we can do it in regulations. Mr. Shen, do you have a view
Just
on that?
2 points, and I apologize. I believe some of these issues have come up in prior commission meetings on the subject. So in terms of potentially penalizing an individual city employee, I think that was in an earlier iteration of these draft regulations. One of the issues mentioned in that respect is that if that were a possibility, we would have certain meet and confer obligations with the affected employees' unions, authorized representatives. The Ethics Commission has done extensive meet and confer processes before with the statements of incompatible activities. That's not necessarily a barrier that we couldn't overcome, but did want to mention that just procedurally. In terms of if we were to stick with the current proposal of essentially moving money from one department to the general fund, it would be the city attorney's recommendation to actually implement that small piece of this proposal via an ordinance instead of a regulation. When we start talking about moving money from one department to another, that's generally done through the budget process, which in itself is legislative. And so that we would perhaps need the authorization of an ordinance versus a regulation.
When you say perhaps, what do you mean?
Well, I have had some discussions with the Controller's Office about how to actually make this happen. That is the recommendation, that, you know, if we're moving money from one department to another, that it should be done through an ordinance.
And is that because the regulations would be ineffective? Or?
Right. To essentially de-appropriate money from one department and move it to the general fund. That is something normally, you know, apart from the Sunshine Ordinance, apart from the enforcement purpose, just generally in terms of how you move money around from different accounts belonging to different departments, is generally done through a legislative process, through an ordinance, and not through regulation.
Commissioner Studley?
I think on a sort of cost-benefit basis, it's a lot of effort and energy by us, by these folks. I don't think $5,000 is going to change behavior. I think if there are places where it's appropriate to have individual penalties where those suit the circumstances, I agree with Commissioner Rennie, that may be a tool that we want to have available individually for severe cases. If we're going to go to the trouble, I'd rather explore the idea of whether we could put a hold on a more substantial amount that would pause funding to the agency, which would be more attention-getting than $5,000. And that may be far too complicated to do, but at least it seems to me we'd be matching the frustration with the action with something that might get attention in the agency. Now, if it's not your first 5,000, if it's multiples of 5,000, then you start to have a problem, and it would maybe be on people's radar. So
yeah.
if I expand my mind to picture recidivism, then maybe it is a useful tool to have and worth seeking.
I do think, although a small amount maybe compared to a department's budget, I do think it could have an effect. I mean, especially with tight budgets, I think every amount's going to count. The question of whether we can actually make it happen, I think, is another issue, whether it's worth it. I mean, I think the intention here was to give us some teeth, because as a practical matter, there's some concern that if departments didn't want to comply, there's perhaps not much we could do about it. Any other
The website,
thoughts?
The website posting does invite other communication methods, not just passive, but something more active that might also have some teeth or effect on people.
I guess I start out with the naive assumption that if, after a full airing of the thing, the commission issues an order to the department or the individual or whoever it may be, the employee, ordering him or her to produce the documents, I guess I would start with a naive assumption that he'll produce them. That presumably that he's not going to simply stonewall and say, I don't care what anybody says, I'm not going to produce them. All right, that may be naive, but it seems to me that all of those employees have supervisors, and whether that supervisor is the mayor or whether it's the board of supervisors, there's somebody over that a communication with him, with that, whoever that individual may be, as to whether they should take some action against him.
Call it optimistic.
Huh?
Call it optimistic.
Not naive, optimistic.
Right.
I suggest that B is probably too problematic to maintain and just remove it for now.
Mr. Chatfield, any different view?
No, I mean, the city attorney's made it clear that the best way to approach would be through an ordinance if that's something you do want to do, and rather than have a provision that we can't enforce anyway, it'd be, if you want to pursue it, it'd be better to pursue it in a way that we could actually deal with.
Yeah. What happens in the situation where we have the show cause hearing, the defense is that advice of counsel. Looking at it, we think the advice of counsel defense lacks merit. What happens then?
I mean, I think that would be just a factual matter for you to determine if you believe.
But if we were to order the document produced, we found the defense lacking, they don't turn it over because they did get advice of counsel saying they shouldn't.
Mm-hmm.
How do we resolve that?
Well, the ordinance itself, I mean, apart from the remedies we've done here, the ordinance itself would allow that person to go to court to try to get the city to produce the document. We would not be able to initiate a court action for them. That would have to be their next step. I mean, maybe that's some advice you could give them as the commission, but apart from the penalties that we've done here, I don't know if there'd be anything further from that point forward. Mm-hmm. Apart from it, I mean, you've already issued an order saying produce it, and they don't. You know.
Okay. Any other views from the commissioners on this particular penalty? 2.1G. Any comments? Okay. Let's take public comment on decision point 2.
Bruce Wolf. I just want to start off by saying that, most of us here are really here to help and make this work, because a lot of us who had been on the task force worked very hard and with you on this. So you don't want it to be adversary in any kind of way, but to offer, suggestions as to how we see things to be either appropriate or better or whatever. So first, I think it's important to separate 6730C from 6734. I mean, the willful failure, meaning official misconduct, that is completely within your jurisdiction. You deal with it in the way you deal with official misconduct cases. That's something that the task force has no bearing over. That's how you have to deal with that. But under 6730C, it's very specific that it's for remedies and enforcement only, not for re-adjudication. And I'm hearing a paradigm that you want to somewhat determine this concept of showing cause is to kind of re-adjudicate the case to see if the task force did what it did properly or not. And that's already has to be assumed. It has its own legal counsel. It goes through extensive deliberations. It's a full hearing process at the same time. And after it has 2 attorneys. It has an attorney that sits on its body, and it also has its legal counsel from the city attorney's office. So you have to assume that whatever it has deemed as a determination to be true, and that what it's asking for you to do is provide the enforcement for that. And I think that's a twofold aspect. The first fold is, as Commissioner Rennie and Commissioner Studley had pointed out, is that it's to get them to do what they were supposed to do. They already had the opportunity to tell us or tell the task force why it's not a public document, or why. And under 6730C, it's not just public documents. It includes CPRA and the Brown Act, state laws, not just Sunshine. So they have to show the cause there. They would have already done that. So the hearing process is already done. The evidence is already there. The show cause is already there. It's already in the minutes. It's already in the orders of determination. There's no need to repeat it. So I think what's important here is after all that is said and done, your deliberations is just what is the enforcement? First, get them to do what they were supposed to do. And then if they don't do it, then that could be considered willful failure, and then you can move forward. Okay? Am I making sense?
You are, except that when we met, this was sort of the compromise position we came to, that we weren't willing to just enforce, but the idea was that we would give the task force the presumption, have a show cause hearing at which the respondent would have the burden of proof to show why a violation did not occur, and then we would make a decision. So, I understand your point, and I know you made that argument when we met, and I respect it, but the decision that we as commission made was that we were going to have this kind of process that was sort of a hybrid, that wasn't a redoing and a reinvestigation, but also wasn't merely enforcement.
But it sounds like an appeals process. It sounds like if they didn't get it at the first trial court, then they can go for an appeal, and this would be the appeals. And that's inappropriate because the Sunshine Ordinance doesn't provide the Ethics Commission with that jurisdiction under 6730C. It could take it to anybody. It could take it to the city attorney, which doesn't have a process like this. It could take it to the DA, which doesn't have a process like this. It could take it to any other appropriate body. It chooses to, as this being one of those bodies, because you already perform those functions in other areas. You already have schedules of enforcement and penalties. And I think, under certain circumstances, it's assumed that all documents are public. It's the burden of the respondent to show that it's not.
And he does have the burden. Thank you, Mr. Wolf. Appreciate your comment.
Patrick Manetcha, I've got a number of problems with this entire series of decision points in 2. One, in 2.1A2, talking about it's on page 7 of the version of this that's sitting on the table. Again, it says when you had this conversation about rewriting 2A12 A and B and C about willful violations versus non-willful violations, again, it doesn't mention city managers. And here we're talking 67.30A, not 67.34. I think some kind of phrasing in there about city managers, since that phrase exists in the Sunshine Ordinance, should remain in this particular section. Moving along to 2-2E, I noticed, again, there's a numbering problem. Section 1A dealt with going on to Arabic numbers following the A. This section picks up with lowercase numbers in parentheses, and it's just confusing that you go from 1A1 to 1A2 and 2A to a Roman numeral. The numbering in this thing needs serious reworking. In addition, on that section 2-2E on page 9 of the version of it that's on the table here, subparagraph C and D shows that you're attempting to, while deliberating and finding, that you're offering in your regulations mitigating and exculpatory rationale in your process. I don't think you should provide for any exceptions that they had relied on good faith for an exception provided by the Sunshine Ordinance, because, of course, those exceptions have to come from SIPRA and the Sunshine Ordinance. In D, they should not be let off the hook because they've relied on the advice of another city officer or the city attorney. If another city officer and the city attorney are wrong, they should all be found to have violated the ordinance. Just because they come in here and claim that they're relying on someone else's advice doesn't really let them off the hook under any kind of exculpatory basis. In F, again, 2C and D, whether it's an isolated incident or part of a pattern, or whether the Ethics Commission previously found a respondent had violated the ordinance, does not excuse their behavior on a new case. That should be taken out. I guess that does it on this section.
Peter Warfield, Executive Director of Library Users Association. Certainly, it's great when you refer back and forth to different documents. As I've mentioned, none of the documents were mentioned in the agenda, and it's not clear when you were talking about things. A point of information, which I stood up to try and get recognition for, am I correct that there is not for the public any copy of the Sunshine Ordinance in the room? No. Thank you, Mr. St. Croix. I think that's really quite stunning and quite shocking. We have a grand city hall. We have a multi-billion-dollar budget. We are talking about the Bible here that we are referring to, and we don't have a copy for the public. That's pretty stunning.
Mr. Warfield, we'll offer you one. You want one?
Thank you. I would like one for the public, certainly to peruse. Certainly I'm glad to have a copy, but I'd like one available for the public, and preferably one for everybody. You've got 12 different documents in multiple copies. How about a Sunshine Ordinance, since that seems to be what we are talking about? I have a lot to say. Mr. Wolf was quite right. Re-adjudication, I think, is a whole wrong approach. Another point of information, if I may suggest, for those members of the public who have bladders, please have a mercy break for us soon. With regard to the You know, I was thinking of a wonderful old slogan for a terrible old bread. For those who are old enough to remember, wonder helps build strong bodies 12
ways.
Thank you. And this is chock-a-block with way more than 12 ways for people to wriggle out of accountability and responsibility over and over again. I do appreciate that many of the members here have pointed some of these out. First of all, let's go quickly, page 7, filing complaints. It should be clear for an ordinary person, what is a show cause hearing? Define it or else say, hold a hearing to show cause why the complainant should not get what he or she wants. Something along those lines. Not everybody knows what that is. On A to B, why not say a fixed time limit like the Sunshine Ordinance provides for provision of documents, for hearings, 45 days. The fact that you're not clear about who's holding a hearing and what the consequences are is stunning, and that really needs to be cleared up, as you've said. Why, to Commissioner Hayon, would they not show up? Because it's real easy to evade accountability, and the respondents, particularly the library, have frequently not shown up so that they don't have to answer any questions. There's a whole range of stuff here, including the part that you correctly want to get rid of, all the excuses in A, B, C, and D, and as Patrick Monet-Shaw pointed out, C and D. Where is the recommendation for removal from office? I don't see that anywhere, and it is in the ordinance. And then I hope you...
I don't think we can do that.
Richard Ney, to refer to the ordinance as the Bible. That may violate the church-state separation doctrine, but we can go into that later. 2-2D suggests complainant respondent speaking time limit to be determined by the chairperson. I would suggest that it's best to actually prescribe in writing, perhaps with some flexibility, a maximum or minimum time range so that the parties know going in approximately how much time they'll have to make their presentations. And the same thing in 3-3A, by the way, same thing. 2-2E and also 3-3B. There's a difference between the two in language. 2-2E says 3 votes are required to establish a respondent did not commit a willful violation. 3-3B says 3 votes are required to establish that the respondent did commit a willful violation. I don't know if those differences are intentional. If not, they certainly need to be addressed. 2-2F and again 3-3C. Neither addresses what will happen if a respondent fails to comply with the Ethics Commission order, or if the respondent's employing entity refuses to pay a fine. And by the way, I think finding an agency is really could be counterproductive. Not a great idea.
Finding an agency meaning
Fining?
Finding an agency.
Finding an agency. I don't think it's that good an idea.
Okay.
Good evening, Commissioners. My name is Dr. Derek Kerr. The term complaint runs through this document, and I'm concerned because a complaint is fundamentally different from a sunshine referral or an order of determination. And by mixing all of these terms up, we lose exactitude, which will come in handy at some point. Also, by equating a complaint with an order of determination, you're treating a citizen complaint the same way as the careful deliberations of the Sunshine Task Force. It doesn't make sense to me. And just keeping the word complaint in there because that's how the document was drafted and it'll disrupt some of the paragraphs, I don't see that as a sufficiently strong argument to keep them all mixed together. My second point is where a representative can come before you, and you include a member of the Sunshine Task Force could represent a complainant. The problem is that this compromises the role of the Sunshine Task Force. They are a neutral review body, and to connect them with the complainant or with the respondent compromises their position. So they should not represent anybody except their conclusion. Thank you.
Paul Currier again. I have 3 points that come to my mind. Number one is the whole issue again of complaint referral. I've been at the Sunshine hearings, and all of you need to go and just pay attention. It's so simple. First of all, we need to have a Sunshine Task Force. Then you can go visit like David Campos did or a number of the supervisors do, see how they work. Because what goes on there is a trial by merits. And when you take a judicial proceeding where the judge on the trial by merits, they go ahead and everybody refers back to the judge and the judge's orders and the transcripts because that was the person that heard all the evidence. That's what the Sunshine Task Force does. So we don't have to reinvent the wheel there. The goal was to try to give Sunshine a little teeth. Number one, we were hoping to have, as citizens of San Francisco, we were hoping to have some cooperation between the Ethics Commission and the Sunshine Task Force so that for instance, this whole procedure is 12 years in coming. We've been waiting 12 years for the Ethics Commission to figure out a procedure to deal with Sunshine referrals other than just throwing them in the trash can, which has been going on again and again and again. So we get to this issue of teeth. And the San Francisco Civil Grand Jury, in this issue on number FB, where it says the Respondent's Department, Commissioner, Board is to pay a monetary penalty to the general fund of up to $5,000, right? This idea was that money was supposed to come out of that department's budget, and that's what the San Francisco Civil Grand Jury thought was a good idea. So this might be something that we should include, because like Mr. Hurd did accurately note, every dollar counts in the tight times. These are $5,000 increments. These are nice big notes. I'd like to get a couple of $5,000 notes, you know, and at no point is there any money given to the person who's actually suffered the damage, who's gone through months and months and years of grievance dealing with city people that, well, I'm not going to review Ms. Gomez's case, you know. Wow, how incredible. Anyway, and then I have this concept of, since we're dealing with teeth, let's move from money to removal from office. Because it says in 6734, willful failure shall be official misconduct. In Sunshine Case 11048, we have Supervisors Chu, Marr, Wiener, and Cohen that have committed official misconduct. The case was referred to the DA for criminal prosecution. It's coming before you guys, and are they going to be removed from office? Because that's what teeth is. You know, we'd like to see that. Thank you.
Hi, I'm Hope Johnson again. I'm going to try not to repeat. There's just a lot of stuff there. I agree with your decision to delete the assigning hearing officer because there would be a question about how you would then vote on it. On item 2C, I think that we do still have some concerns that the executive director should not be re-adjudicating these behind the scenes with the similar memos that we receive that you guys don't vote on but end up getting posted as dismissals without a vote. So we just want to make sure that that doesn't get lost in the interpretation. In D, I do not agree that either the respondent or the complainant should be able to have a representative when we were in the task force hearings, we found that they frequently sent representatives who just kept saying, I don't know, I don't know. And so they did not send knowledgeable representatives. Also, the city attorney's office is not allowed under the Sunshine Ordinance to represent the respondents or to provide advice to withhold documents. I agree with another member of the public who said that it would be compromising and set up an adversarial role between the task force and the Ethics Commission to have a member of the task force represent the complainant. I also agree with your decision to eliminate in Section E the points that mitigate their the circumstances surrounding whether or not they turned over documents or violated the Sunshine Ordinance. One thing I would like to see in F, under D, it says that, the very last sentence says that you will not take further action on the complaint. I'd like to see something in there about maybe following up on the status of a recommendation such as you're going to consider in the Jewelle Gomez case, rather than just letting it end. And I understand that other people have spoken to this, but I just want to put in my support for not weighing too heavily on re-adjudicating, because it may become sort of a slippery slope where the Ethics Commission begins to take on the role of the appearance of overturning task force findings, which it doesn't really have the authority to do. So to keep that in mind in the hybrid process. Thank you.
David Pilpel. Yes, there's a lot here, so let me make some points. Chapter 2, Section 1, Sub A, filing complaints. I'm not sure that that's the best heading, perhaps hearing of referrals, something to that effect. I'm also not sure, in hearing and thinking through all of this, whether this show cause hearing is a quasi-adjudicative matter, whether it's a legislative matter, whether it's a legislative hearing with some aspects of the other. I'm just trying to think through what due process rights a respondent would have at this kind of a show cause hearing. And that may turn in part on whether there's a financial penalty or a finding, and whether that attaches to them as an individual or to their department or agency, and what sort of rights are implicated there. I'm still thinking through that. On sub B, scheduling of the hearing, I would suggest a minor language tweak to say scheduled pursuant to the agenda and notice requirements in the Sunshine Ordinance and the Brown Act, because it may not just be 67.7 and it may change in the future. And I think that's also consistent with language elsewhere about in accordance with the Sunshine Ordinance and the Brown Act. I appreciate not having the hearing officer. I don't know if you resolved whether it could be a single member of the commission holding the hearing, or if it's going to be the entire commission regardless. I heard what staff had to say, but I wasn't clear on whether you changed that language to just say the commission shall hold the hearing.
Do you have an opinion? I don't think we've decided it.
I think if the commission is going to deliberate later on the merits in any event, then you should probably just hold the hearing before the entire commission. I don't know that you need to set that. You could set that within a week, as I think Commissioners Rennie suggested, but I don't know that you need to hold that within a week. That may require some scheduling and also be dependent on the rights of the respondent. But if you're going to hear it anyway, why sub it out to somebody and then have it back? More public comment, more hearings. You want to just deal with it. I also think in general in this section, it largely turns on documents, and I would note that this is not a 21D or 21E matter in the ordinance. It's actually a referral that's a 30C referral whenever the task force concludes that any person has violated any provision of this ordinance or the acts. So it's either a finding or it's remediation or it's something, but I don't know that taken together, that this body of law gives you the authority to order disclosure of records, or to the extent that you have the power to order anything, that it's limited to just records. I think it's more broadly enforcement. Let me just conclude with a couple other things here.
You can turn it back on.
The votes of 3 commissioners are required. What happens when you only have 4 commissioners present? Does that mean that the matter dies? It doesn't really address that, and it sort of has a presumption built in there somewhere. And I'm not sure if that makes sense. And most importantly, in terms of the administrative orders, there's nothing in here that suggests that the commission can make a finding that a violation was in fact willful. And I think that's, to me, kind of the most important thing in 67.34. If the commission finds that an act was willful, then it shall be deemed official misconduct and all of the things that flow from that, which other speakers have talked about. I think that's actually...
I don't think we've gotten there.
No?
Right? I mean, the willful... You're talking about willful violations that are... Oh, you're talking about willful violations of... based on findings that are made by the task force. Okay.
Or made by the commission. In any event, that a finding, if you look carefully at 67.34, I think if the commission determines after the task force has done whatever it's done, that an act or an omission was willful, that official misconduct attaches to that and whatever flows next out of that. But I don't see that written up in sub F under admin orders and penalties, that the commission has the opportunity to make such a finding of a willful violation. I think that's critical.
Okay, that's
enough for the moment. Thank you. Thank you very much.
It's hard to look at each of these various decision points separately. I think globally you have to understand, at least it's our understanding, that a show cause hearing can't be a do-over. It can't be a repeat of what the task force did, which was to hold several hearings, entering an order. The respondent was given every opportunity to prove that an exemption applied, and he didn't comply. Public records are presumably disclosable. The respondent has to establish either that disclosure is prohibited or exempted. That was all done before the task force. If you want to do it all over again, which is what this will entail, then why should the task force even bother in the first place? Because it spent a lot of time, a lot of effort to get this matter to the point where the complainant was supposed to get either his records or some other matter taken care of, and it comes to you and you do it all over again. I want to make another point. I didn't pick up whether the advice of the city attorney is a defense. It can't be, because under the ordinance, the city attorney cannot advise any city employee, assist any city employee in, I could read the language, shall not act as legal for any city employee having custody of any public record for purposes of denying access to the public. But if you want to keep it, it becomes a get-out-of-jail card, get-out-of-jail-free card. The other thing that I think is important is that I think the full commission should hear these cases. I think the public is entitled to that. I think the complainant, the original complainant, is entitled to that. And the notion that a hearing officer who is unknown and has no real accountability would be involved is just contrary to the spirit of this arrangement.
Can I ask you a question about that, Mr. Grossman? So in the situation where, because of timing issues, that's necessarily going to cause potentially more delay between the Sunshine Task Force finding and the commission finding, you think it's worth it to have the full commission decide it?
Well, Mr. Minette Shaw's case has been sitting for over a year.
Look, Mr. Grossman, can you just answer my question? Is that, I mean, because I really am curious, and I don't really want to hear, we're going to address Minette Shaw's issue tonight.
I think it is worth the wait to get the full commission to hear it.
Thank you.
And the other thing is, these violations are not alleged. They actually have been found to exist. And that's what the order meant.
My name is Decha Bowler. As a kind of outsider to these proceedings, I need to say that the absence of the original task force document that says what I get nervous talking, so I don't make sense sometimes. Let me back up. I have a draft version of a lot of articles. And then there's this other one that isn't marked draft. And so I had to figure out, as a naive observer, were there changes between the draft and this document? And I half concluded, well, this document is what is already in existence. But then I realized that, no, there isn't a copy of the task force regulation, the original. So these two are, I think, as far as I can figure out, the same thing. So that I pointed out, because it makes it impossible for me to understand as a member of the public what you're doing here. These are not, I don't know if these are new regulations or slightly changed versions of the old. I can't think of the word for the governing document for running the task force. So I don't have access to that, so I can't make sense out of your intended changes because I don't know what's being changed. I don't know what it might be a change from. Lacking any response from anybody, I don't know if you've understood what the predicament is and why I'm concerned. I get one nodding head.
These are the Ethics Commission's regulations. The task force, there have been many iterations. We have been trying and working with the task force for some time to try to come up with regulations that we feel meet our charter requirements. The task force has had views about how we should handle these things based on their interpretation of the charter, and we are presently trying to bridge the gap, and it hasn't been an easy process. It's been an extremely difficult process.
Well,
and this is the closest
I see.
we've gotten to date.
Yeah, well, I understand that. I just don't know what the regulations are that are in existence from the documents that I've been provided. And I don't know if you realize, if I've made that clear, that I can't know, as a member of the public, I can't know what these are changes to.
These,
I think that's what B is.
yeah.
Do you want to explain?
Go ahead.
I think you'll find there are three pieces, and here's how they relate to each other. There's a document from September 14th that explains the thinking about the recommendations and breaks the changes down into pieces. It's the one that looks like that you're holding. Attachment B, somebody stop me if I'm doing this wrong, is what the larger regulations look like and what they would look like once they were changed to track what we are doing now. And the one that says draft and effective date is if you take all the things that we are changing right now and put them into what we were doing, that's what it would look like. Have I got that right? So one is looking at it step by step for the changes, and the other two tell you what it would look like, and they underline or show you what would go in or what would come out.
I see. I don't think I...
If we did all the things that were suggested in this memo.
Yeah, I didn't follow the second document you're referring to. I'm not clear. No, that was the third.
The second one is the one that says attachment B at the top of it.
Oh, I don't have that.
It should be available
on the
over there
table.
on the table.
But will that then tell me what the standing regulations
Yes.
are?
Yes, yes.
Oh, thank you.
Thank you. What is that? Pardon me?
Yes, thank you. Speaking as an anonymous citizen, of course, I think the answer that Ms. Bowler wanted was that there are no regulations at the moment, and this is an attempt to respond to the fact that there's been no enforcement for the past 17 years. I have not done my own work on this. It's been a number of years since I was on the task force, but I was at the hearing a year ago, August. And from that, I think there are some clarifications that need to be made. First of all, with respect to the filing of complaints and the exceptions, it says willful violations by city officers other than elected officials, department heads, and city employees. The reason that doesn't track is that what actually it says in 6734 is department heads or elected officials, department heads, and other managerial employees. And the idea is, if you remember your high school grammar, that it's a non-restricted clause, and that even though with respect to official misconduct, it defines department heads to include other managerial employees, it does not restrict your hearing process, which should be reflected here and in the next chapter, Chapter 3. With respect to the representation of these complaints, I've always felt very strongly, it's less clear in the current task force, that when a citizen brings a complaint to the task force, the citizen has done his part. And from that point, it's up to the task force to advise departments, city employees on the enforcement of the law. And if that means referring it somewhere else, the task force itself is the interested party at that point. It's not up to the complainant to turn this into some steeplechase or obstacle course and block the complainant at every instance, because the entire city has an interest in the enforcement of that law, and it's that operation that has the interest. With respect to the findings, you have qualifications here for whether a person relied in good faith or whether there was advice. Of course, that might be referrals relevant with respect to enforcement or fines or something, but the actual finding of the violation, that's completely irrelevant. It's still a violation, whatever they relied on. Thank you.
Can I just ask you a quick question, Mr. D? So you would have the task force be the spokesperson for its decision before us, and have the respondent when we give the respondent the opportunity to show that the finding should be overturned, that we should not act on it.
Well, I would
But
say.
you have the task force be the spokesperson, not the complainant. I'm
Well, I
using the
would
word
say that if
spokesperson,
the
but-
complainant does not wish to show up, then the task force itself should be able to show up to make sure that the issue is pursued, because it's at that point.
Not as the
it's just-
representative of the complainant, but as the speaking for the task force. Is that
Speaking
what
for
you're
the
saying?
issue, yes, for the task force itself, but in effect, advocating for the order of determination.
Thank you.
Okay, a couple things have become clear to me through this process. First of all, I have felt and still feel that the staff did a very nice job with these, because this is a difficult issue, and we've been trying very hard over the course of quite a while to come up with regulations that we think work, that comport with our view of the charter and our responsibilities, and also take into account what the task force feels is necessary here. So, I do think that the staff has done a great job with that, and I appreciate that. That said, whenever you're doing regulations, it's a complicated process. You hear from the public, you learn things that may alter how one may want how one may want these regulations to look. So I do think we should go back and rework parts of this. I'm not certain that it makes sense at this point to pass what we have and amend. I think we should probably work a little more to revise so that we have something that takes into account some of the issues that have been raised. So my recommendation is that the commissioners, we go through the rest just for the commissioners to identify specific areas of concerns they had, because we can't share them unless we're doing it at this meeting. So I think that would be helpful.
I'm fine with that process, but we could convey them to the staff that they are issues that we would raise so that they can anticipate and prepare them, if you're thinking we would do this without discussion. If you want to have discussion among us, obviously.
Well, I think, I'm not sure how much change people have, but I think it would be helpful to hear the views and have some opportunity to discuss them. I'm getting the feeling that we probably shouldn't vote on this set of regulations today and sort of jam them through when we could improve them. That said, I'm also not committed to waiting necessarily for the task force to get together and review them. I think the comments here have been very helpful. If the task force does end up meeting and we can make that work, we will. But these are our regulations. We need them. We have complaints that have been sitting quite a while because we've been trying to get this done. So we, of course, need to balance the desire to have the best possible regulations with the need to have regulations that address this issue. And I hope the public understands that it's not going to be perfect and that we need to somehow find this balance. So if the commissioners are all agreeable to that, then I'd ask that we share our comments with respect to anything in Chapter 3.
The only comments that I had on Section 3, public hearing, is there's no language about when, there's no language when the public hearing should be heard. In other words, how quickly after staff done its investigation. And I just, but other than that, and I think based upon the comments tonight that we ought to probably eliminate, particularly under Section 3, any concept of an individual commissioner holding the hearing, that it should, under willful violation, it should be the full commission. It's the only comments I have on it.
Any other comments from the commissioners?
Just briefly, it's under decision point 3-3C on page 14. And it also happens in the prior section that informing the respondent's appointing authority makes me wonder whether there is some parallel or something we could do that was effective with respect to elected officials. Because we don't have a comparable place to take it until, except for the obvious next opportunity the voters have to vote on an individual. So simply saying, I wish I could think of a way that we could do something that would have some effect.
Is there anything we can do?
You could inform the mayor, because I believe under the charter provision, it's the mayor who initiates the removal proceeding for an elected official. So,
as we're aware.
Right. So that's what would happen in that case. But we can certainly add language to make that clear that it would go to the mayor.
Or flag in here that the mayor, yes, that we could go to the mayor. Inform the mayor if it were, with respect to such a person. That's it.
A brief point of order. Since closed captioning keeps cutting in and out, may I respectfully ask Commissioner Rennie to please speak in the mic because of my hearing disability. I can't hear what he's saying when there's no closed captioning.
I apologize.
Any other amendments to Chapter 3?
I guess we make the same amendments on the deletion of the subparagraphs and the deletion of the, or at least raise question about the monetary penalty.
Yes. Agree. I had a question about the report and recommendation, decision point 3-2C. What sort of declaration to support the report and recommendation by the executive director was contemplated? What were you thinking there?
That was in the event, say, that if someone, say, like an elected official was sending a representative if they wanted to submit a statement or something along that line. That's all. Or if we interviewed a witness, say, and the witness didn't want to come, that we would have the ability to have a written document from them to say, this is what I saw, or this is what I was told, or along that.
Okay.
I have a question on the area of investigation and recommendation, Section 2. Just in general, the discussion that has come up repeatedly is that the task force is the one that has already conducted the hearings and the investigation of the complaint and of the complainant. So what is the further investigation then that we need to do, that staff needs to do prior to the whole thing coming before the commission for a final adjudication or penalties?
I think this section relates to instances when it's either a staff-initiated complaint or one where involving a willful violation of an elected or department head that is exclusively within our jurisdiction.
So it's not referring to the complaints that come to us from the task force?
It is not referring to complaints that come to us from the task force for example, for the ones that come through 67.30C. Do I have that right? Okay. Do the commissioners have any thoughts or amendments to anything in section 4, chapter 4? We're not making a motion. We'll
Only do one more public.
We'll do one more public comment on 3 and 4, but we're not deciding anything. Any comments on 4?
No.
I had a couple minor things. The conclusion of the hearings, I'm on page 18 of the memo, section K, decision point 41K. I can imagine a situation where we deliberate after the argument or testimony, and that could happen on a different day. I presume it probably wouldn't, but we may want to add language to reflect that.
Could you just explain why, what this triggers or why it matters to specify this? There must be something I couldn't find that requires us to know what that last day is.
There is no requirement. It was just an attempt by staff to sort of have a sort of a dead full stop of when the hearing's over, basically, and then your decision's been made and there'll be no further action on it. It certainly can be.
So it's not that there's a trigger that
No.
something will happen 30 days from that.
No.
moment.
Well, to me, the trigger was more about sort of compliance. If we say it's got to be 10 days from the date of
From the decision.
right, then it would be helpful to. I mean, to your point, it may not be necessary because
You could just date the order.
you could just date the order, but in a situation where we're making oral decisions.
Yeah, I see the problem.
What
I
problem?
mean, it's not translating at all. That's what Patrick meant. Sorry.
Oh.
Where you were, yeah.
Oh,
The
you're
closed
looking at the closed
captioning, right, the
captioning.
closed
Okay.
captioning is not working. Sorry.
So, I think it's fine to have it, but I would just clarify that. Okay, so L, 4-1L, what was intended there?
So under the charter section that you'd be referring to, that the commission isn't empowered to initiate official misconduct proceedings. It has to come from the mayor or the appointing authority. So what we contemplated was that because in a situation where a 6734 violation happened where there was a willful failure and it's deemed official misconduct, you've already decided that as a body. So if, say, the mayor wanted to initiate official misconduct proceedings, that piece, if that was the only piece or if that was one piece of many charges, would already have been decided by you, and that there would be no reason to re-adjudicate that. I understand it's a little complicated because this body can't start an official misconduct proceeding. It can only send something to the mayor saying this is what we found. So it was an attempt to not have to re-adjudicate what already occurred here.
I mean, it's good thinking. It's complicated. I mean, could we recommend, we can only recommend removal for a willful violation? Or can we do it for a non-willful?
You can state that you found that there was willful violation and that under the ordinance it is deemed official misconduct and send that finding to their appointing authority. I think and Andrew can probably weigh in on this better, but if you were to say, and I think removal should happen, you might already be predetermining something that could come before you, but I don't know if you have any thoughts on that.
Yeah, I think the way that Garrett explained it was made a lot of sense to me. It certainly, as a practical matter, if the commission has already found there's been a willful failure to comply with the Sunshine Ordinance, then it seems like it's a bit inefficient for the Ethics Commission to rehear the matter.
Yeah, I guess here's my concern. So let's say you have a willful violation from a city employee. They're going to go through a show cause proceeding, so the burden will be different. Conceivably, in a situation where they didn't have the burden, you wouldn't find willful violation. And if the mayor were to institute official misconduct proceedings, it seems based on the procedure, at least we've just recently used, we put the burden on the mayor to prove official misconduct, which is different than the respondent having the burden to show that there wasn't a willful violation.
Right, and I think it's also worth bearing in mind that the official misconduct proceedings only applies to a fairly small number of people in the city. It only applies to essentially electeds and members of boards and commissions.
So is it fair to say then that anybody who would be subject to that falls under 67.34? Meaning electeds and department heads? Because we have exclusive jurisdiction for willful violations of electeds and department heads. Are there others who could be removed by who the mayor could initiate removal proceedings for, who don't fit into that category?
Well, I'd have to consult section 15105, because that's where the removal proceedings are. In the case of the other scenario that you presented, an employee that you find willful, I understand that could be a complication because the burden is different, but they also, as Andrew said before, would have different rights about being terminated as well. They wouldn't go through this process at all. So that might mitigate that to some degree. Sorry, Andrew, go ahead.
Yeah, so the official misconduct process that obviously this body's familiar with primarily applies to elected officers and members of boards and commissions.
So I guess arguably the members of boards and commissions would be in a little bit of limbo. Because presumably if the task force found a willful violation of a board member, of a commissioner, then...
Right. So that's an unfortunate example of how the Sunshine Ordinance doesn't quite link up to some pre-existing provisions in the charter, that there's a bit of a disconnect on the subject of members of boards and commissions.
Yeah. I guess I would recommend that we remove this. I think in the situation where we've already found a violation, the likelihood of us changing our mind is low, and but because it doesn't encompass everything, well, we can hear what folks have to say, but that would be my concern. Any other comments on decision points 4? Decision points 5 and 6. Anything? Okay. Let's take public comment.
Okay, David Pilpel. So starting on Chapter 3, as it were, I think my only substantive suggestion was on page 12 of the memo, C2, the report shall recommend, and shall be delivered pursuant to Section 1B2, I would say, and 1B3 if applicable.
Sorry, where are you?
Sorry, the middle of page 12 of the memo, where it refers to Section 1B2, I would say, and 1B3 if applicable. That refers to those referrals from the task force that aren't Chapter 2 referrals but are Chapter 3 referrals. And I guess it's late and I'm getting confused as to which is which, the willful or the non-willful, whatever. Okay. I'll read it tomorrow. I think that was it on Chapter 3. The other things sort of pervaded this and will carry over from the rest. As to Chapter 4, going through these very quickly, I think A and B, C was no problem. D, the designate by the executive director, it's not clear to me how that designation to the public is made known, if that's put on the website or noticed somehow, maybe just some clarification on how that designation is made known to the public. On E, the powers and duties, I think that's going to change based on your deciding not to have hearing officers and probably have the commission sit as the whole panel. Continuances, fine. Recordings, section G, do you really want to require absolutely everything to be carried on SF.gov TV? I'm a big supporter. They know that. We all know that. But this suggests that everything. So,
are we required to show up on TV anyway?
Yeah. So maybe this is just redundant from what the commission has already provided for in its bylaws. If it's doing something other than what's in the bylaws, then that's not clear to me. Statute of limitations, top of page 18. I'm sure we'll hear from others about that. I too don't know where that comes from, whether the commission has the authority to set a one-year statute on these actions. I don't find that anywhere. On subsection K, the conclusion of the hearing, I would suggest that the hearing concludes when the commission has made a decision, and I think that was the suggestion of the language that you were adding, but it too isn't clear here. Just because you're discussing, once you've made a decision, then and an order issues, I think that ends a proceeding. I agree that 15.105 should not be in here, and as to 5 and 6, clearly we're not taking action tonight. I would suggest that in the next hearing, when you are considering taking action, that it be clear that it's both adopting these regs and amending the other regs, because that's not entirely clear in the write-up, and that 10 days notice be given under 4.104 of the Charter. Thanks.
I just wanted to speak to it on page 18. It's 41H, the statute of limitations. I don't think that the Ethics Commission has authority to impose a statute of limitations. There's no state or local authority that does that, and it's a mildly arbitrary, that first sentence, that it's from the 1 year after the date on which the original public records request was made. As you know, a lot of circumstances can delay. We've had, for example, there was a case, a task force case, where a complainant requested records of Kamala Harris, they then waited until after the election. That took maybe 4 or 5 months. So that is something that I don't think it's appropriate, and I think that you should reconsider having a statute of limitations. I think people would challenge your authority to do that. There may be something that you could do on your own regulations and deadlines, but I don't think that you can say that people are unable to allege a violation of the Sunshine Ordinance. I mean, certainly they can do that at any time. So that's my only comment on those things.
Peter Warfield, Library Users Association. First of all, thank you for the good questions and the good comments that you have made and the improvements that you've been making as you go. Hope Johnson did write a letter, which I hope she forwards to you, and it points out some very important things. So let me just talk in general terms. The draft regulations implying that there's a limit to the number of records that may be requested, I think that's highly toxic and should not happen. We know that FOIA requests, some of them very significant. I just heard Seth Rosenfeld, who's got a book, and he had tens of thousands of pages that he requested from the FBI on the subject of his book. He got them eventually, but he got them. I certainly try and limit requests that I make very sharply by date, by subject, and I also ask people to let me know if this is going to be more than a certain number of pages. But I think that having some kind of a limit on the number of records that may be requested. Let's face it, these are all public records. They were all created or kept by the folks that are representing the public, and they should be public. The other thing is about a statute of limitations, as Ms. Johnson just mentioned. To put a statute of limitations on the Sunshine, any aspect of Sunshine, I think would be, number one, contrary to public policy. These, as I said earlier, are crimes against the very way that we supposedly run our government and our democracy. These are violations of things that allow our government to work properly, and the press. It would, in effect, reward people and give them the fruits of their successful evasions, cheating, hiding, and withholding. If I don't even realize that, for example, a commission has improperly noticed some action that has taken place in the past, and I now see some evidence of the results of those actions, and I now realize I didn't realize that was happening because there was not a proper notification on an agenda, that should not have a statute of limitations. I can give many other examples, but I won't. I think you get the point. One of the things that I think is very important is that where possible, folks should not get away with the fruits of their unlawfulness. If they get an approval for something that they did unlawfully, there should be a way to deny them the fruits. It's not always easy or possible, but in some cases it is, and that needs to be thought about here. Thank you.
Thank you.
Patrick Minette-Shaw. I'm hoping, Commissioner Hurt, that when you schedule another hearing on this, that you'll just take sections 3 through 6 and schedule a reasonable hearing just to go over these points, because you can't possibly expect members of the public not to be able to address each of these issues tonight by lumping them all into one 3-minute section about 4 major sections of your proposed regulations. So trying to fly through this quickly, this idea that the volume of records requested could somehow mitigate whether a referral sent to you for enforcement was willful or not has got nothing to do with whether it was willful, nor does relying on the good faith of some other city employee, including the city attorney, who's not allowed to give advice to city employees about evasion of the Sunshine Ordinance. For decision point 3C1B regarding monetary penalties, again, as you may well remember, the civil grand jury recommended that penalties come out of departmental budgets. That, Commissioner Studley, will address your behavioral change issue. That when it comes out of the department budgets, as the grand jury said, it will effect change in management behavior. As far as the statute of limitations, Ms. Johnson was absolutely correct. That needs to be taken out of here completely, or you will be exceeding your authority. Oh, speaking of which, I noticed that you answered David Wagner, Commissioner Hurt, that you didn't have to tell him whether you read that anonymous analysis of the Mercarini case or not. But let me share with you that that analysis shows that you exceeded your authority as an ethics commission. Are you going to do it again by adopting proposed regulations that are not well thought out and that you may exceed your authority under the charter? Won't that bring the wrath of Supervisor Wiener down on your appointment the way his wrath was brought down on Mr. Wolf? By exceeding your authority, Mr. Wiener cannot possibly not find the same result in your behavior.
Paul Currier, hello again. Just a couple of simple points. I didn't find any statute of limitations in reading of the Sunshine Ordinance. If you can find one, I'd like to get the education and direction from you. Number two, the Sunshine Ordinance is all about the First Amendment rights of citizens. And this really matters to us in San Francisco. It's beyond a freedom of speech issue. It's also a freedom of access issue. For instance, when we're dealing with the mayor's Public Housing Commission, commonly known as the San Francisco Housing Authority, President Amos Brown loves to say, this is a federal body, this is a federal body. You know what? We went to HUD in Washington, D.C., and HUD said, that's not a federal body. That's an adjunct of the mayor's office in San Francisco. The San Francisco Housing Authority is a San Francisco entity that's funded by the feds. Okay, so the Title 24 applies, and when we're dealing with, HUD said in Washington that the Housing Authority has to obey all local and state law. Local law is the Sunshine Ordinance. And we're getting a runaround again and again and again over illegal elections and all kinds of, there's millions of dollars being stolen by the councils, the residents' councils. It's off the hook, and nobody talks about it. And then I want to mention a couple of points on the rush through this process here. There's a pattern of rushing through the process. And when the Sunshine Task Force doesn't have one member who's disabled, they stop. And when the Ethics Commission hasn't when the misdemeanors are going on and the meeting is not properly agended, and ADA violations are going on, you have an obligation to stop the meeting until the corrections can be made or you're under liability for ADA lawsuit. And so this is stuff that, like, it should be elementary in San Francisco, that especially the Ethics Commission behaves in an ethical process, an ethical manner. And in closure, I want to come back to, did you remove proceedings in the charter from the deal from the final document on 15.105? Did I get that right?
We haven't taken any action.
All right, thank you so much, because this issue of removal from office is something that really needs to come forward, especially when there's such a unequal application of the laws in this city. Thanks.
I'm not sure I heard it right about 6734 because, it's back on. Okay. There are two provisions in 6734, one which defines official misconduct and one which discusses willful violations of the law. The official misconduct provision talks about a willful failure of any elected official and so forth to discharge a duty imposed by the ordinance, the Brown Act, it is Public Records Act. There are actually 16 places in the city charter where there can be a finding of official misconduct. There's this one plus 15 others. At some point, you're going to need regulations on how to handle that. Admittedly, the charter provisions are a mess once you move away from what the mayor can do and what the mayor can't do. But you still need the regulations. The other problems I have, obviously the artificial statute of limitations, 1 year from the date that records were asked for, it makes no sense, and I think it's probably too restrictive to stand up to the constitutional requirement of how you interpret laws affecting public access. There's also a provision that the notes of the investigative individuals on investigating individuals are to be kept confidential until the decision is made. There's no basis for keeping any of those records confidential. That's been established. I think the case I filed a couple of years ago probably established that principle. Other than that, there is, any number of glitches and such, but I really think that taking another look at it is very helpful. Thank you.
Okay. So we'll work on those. Thank you for your comments. I think they were helpful, and we'll keep trying. The next item on the agenda is consideration of a draft follow-up letter regarding Jewelle Gomez. Does anybody anybody need a break?
Soon.
Okay. Okay, let's take a break after we get through this agenda item, and then we'll resume. Do you want to introduce this matter, Mr. St. Croix?
A couple of the commissioners had expressed interest in agendizing this action taken by the commission at a prior date, just for the purposes of determining whether you were interested in requesting an update on follow-up actions by the mayor. So the thought expressed was that possibly a follow-up letter would be drafted and sent. The staff took a liberty in drafting a letter for the commissioners to consider or edit, provided you even decide to send one.
Any comments from the commissioners? Commissioner Studley?
I do think we should send a letter. If the sense of the other commissioners is that we should, I have some comments about the specifics of the letter, but I think it's pretty close. And I do think whether we have teeth or not, we at least have a voice and a typewriter.
Commissioner Rennie?
I concur with Commissioner Studley, and I would add to the letter, which I think the staff did a very fine job of, but I think I would add in the last paragraph, after what's written, language to this effect. Alternatively, I request you advise the Commission as to the reasons why you declined to take any action in respect to Ms. Gomez's conduct.
Commissioner Studley?
If we're editing, I think the phrase "with an ability to impose specific penalties" just seems a little awkward. I would say with the authority or power rather than ability. And I guess I wish that I had, I didn't go back to see our specific vote or the letter that we sent initially. But is the wording of the last sentence of the middle paragraph, recommend that you consider taking steps to remove from her appointed office for her conduct, is that the language that we used before?
Yeah. Yes, it is.
Okay.
Any other comments? Suggestion, I don't feel particularly strongly about it, but I wonder whether we need the first sentence of the third paragraph. I'm not sure that we requested that the mayor, did we request that the mayor keep us informed?
No. No, sir.
Okay, so to suggest that the mayor may not have expected to provide us with the response if we didn't ask for one initially.
It's also possible that he did something that is not evident from outside.
Right.
And he doesn't have a reporting requirement to us.
So I would suggest we strike that first sentence and begin the third paragraph with "I am writing." and then add Commissioner Rennie's sentence at the end of that. And then it's typical that the chair would sign on behalf of the commission here, or?
You could, either the chair would sign or you could delegate it to me to sign.
Okay. I'm fine with that, just for logistics purposes, that would certainly be easier.
I think you should sign.
You think I should sign?
Unless you mean the alternative is all 5 of us sign. But I think you should sign.
I don't think we've ever done that.
Having all 5 sign?
Right.
Right.
Okay.
You should sign.
Okay. Public comment.
Thank you, Commissioner Hurt. I commend Commissioner Rennie for an excellent suggestion, but I've got 2 more for you to add. First, I've testified before this body before that Ms. Gomez, when I congratulated her in person for being the first person to have been referred for official misconduct by the Sunshine Task Force, in which you actually held a hearing. She didn't like my sarcasm, which is too bad, because that's part of the First Amendment. And her response, bending over to pick up her book bag and her dropped jacket, was she attempted to strike me with her coat. What's the phrase? You don't have to have battery to have assault, or is it the other way around? Her behavior was reprehensible, and it has sat stinkingly reprehensible in my craw for over a year while you've waited for the mayor to get back to you. So one suggestion is to put in your letter to the mayor, is to ask for an explanation from Ms. Gomez why she thought that behavior in a public forum was, what's the phrase, right conduct befitting an officer of the city, blah, blah, blah. You know, the phrase that the mayor used against Sheriff Mercarini. Was that right action of a public official? Second question you should ask him, on my behalf, if you'd like, in your letter, is to ask him why he hasn't taken any action on Ms. Gomez, who was found by 2 bodies, both of them ethical oversight bodies, who both concluded she had engaged in official misconduct. And when that was brought to the mayor's attention, he chose to do nothing, in stark contrast to what he did to Sheriff Mercarini, which was not official misconduct, as that anonymous analysis that we're still wondering whether you read it. You can't charge the sheriff with official misconduct over false charges and then let a library commission president off the hook for proven charges.
Thank you very much. I do have a graphic presentation, but there are only 2 real points I want to make. First of all, with respect to official misconduct in general, there have been questions about the pending charges against the elected sheriff, about whether it was related to his office and whether he acted in his official capacity. With respect to Jewelle Gomez, there is no question that this took place at an official public meeting and that she was conducting the office that she was appointed to while this was happening. But more importantly, the mayor removed Mercarini while charges were pending, yet he did nothing, not even make a response, after Ms. Gomez was found guilty. Now, you may remember that after this happened, there was an altercation in which some comments of Jewelle Gomez were posted on the library's website. And my demonstration's a little bit slow here. I'm going to play them for you in a minute. Which, the other point you have to understand is this is more than just the tip of an iceberg. This is a tip. It's waiting for me. I played this once before, but there may be people who haven't heard it yet. Well, people who would fucking bury him if I could walk out with the day. Shit, I walked out the ghetto, and I used to carry a straight razor. I fucking had if I could find a phone that microphone there. I would have garroted him. What you have to understand is that not only is she discussing her possible revenge, but she took that revenge by filing a fraudulent police report against the speaker, was not even me. The point is that when the only accountability that she's susceptible to acts and there's no response at all, that's effectively a ratification. And when the mayor does not either justify or respond in any way, he's basically saying it doesn't rise to the level of his attention. He's basically ratifying it. Well, that's like the referee taking a punch at somebody. If you went to a football game, you know, everybody would just go home. Thank you very much.
Peter Warfield, Executive Director, Library Users Association. First of all, certainly do send the letter. I appreciate that you've got it. I only wish that it had come a lot sooner, and I certainly hope that you may have repeated follow-ups. And as a previous speaker said, thank you for the addition that was suggested by Commissioner Rennie. The testimony at the Sunshine Task Force was essentially that her behavior in the room was so shocking and so intimidating that others, not myself and not the previous speaker, said that they were actually intimidated and did not make public comment on an item that they had actually come to make public comment on subsequently. It was the item, generally speaking, that was under discussion by the person who had been violently shouted down. In addition, as the previous speaker mentioned, there was a whole series of follow-up, well, the two speakers mentioned a whole series of, one hardly knows how to describe the behaviors that followed. But which is to say the police report, the apparent, and it was witnessed by somebody else that we heard from at that time about the attempt to hit Mr. Monet Shaw. My mind is going blank for a moment about another consequence. Yes, not only was Ms. Gomez reappointed to the Library Commission, but earlier this year, following your letter and the Sunshine Task Force, Ms. Gomez was nominated as the only nominee by the other library commissioners, who are all appointees of the mayor's office, and was re-elected unanimously as chair of the Library Commission. So I would urge you not only to send this very promptly, but to make it even stronger if you can find it to do so. And I would say that the mayor has taken action in connection with this matter. He has reappointed Ms. Gomez, and he has allowed, presumably, his appointees or his office's appointees to re-elect her without any evident problem or complaint. So if there's any way that you can make this even stronger and undertake to do this more frequently than more than once a year, I think that would be terrific. But this is good, and I appreciate your doing this letter. Thank you.
Is there a motion to approve the letter as amended?
So moved. Second.
All in favor?
Aye.
Opposed? Hearing none, the motion passes. Can we take a short break? 5 minutes enough? 10? 5 minutes.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
Okay, we're back in session. The next item on the agenda is consideration of ethics complaints, numbers 811-0816 and 0911-0816. We have recommendation.
Commissioner Herr, before we proceed with items 5, I would ask the Commission's permission to be excused from any of the proceedings, actually with item 5, 6, and 7. As has been pointed out correctly, my wife, both as city attorney and in her private capacity, has been closely associated with Laguna Honda Hospital and is also chair of the Laguna Honda Foundation. I would, for the record, would tell you I have no idea what any of those complaints are about. I have not spoken with any member of the staff. I have not looked at any of the papers relating to the items which are items 5 and 6. But I believe that it would be more appropriate if I be excused. I'm perfectly willing to go in the back while you are considering those items, or if, with the permission of the Commission, that I be excused from the balance of the meeting as the items 8 through 12 do not appear to be of great substance, but I'm happy to stay if you want me to stay. But I would like to be excused from the consideration of those 3 items.
I certainly have no objection to you being excused for the remainder of the items. Any alternate view from the commissioners?
Thank you.
Thank you, Commissioner Rennie. We need a vote. So we need to make a motion. We need to make a motion as to whether. Is there a motion to accept Commissioner Rennie's recusal?
So moved.
And we have to take public comment? Public comment.
David Pilpel, I just wanted to understand further if the commissioner believes that he might have bias in the matter. If he believes that he can adjudicate the matters fairly without bias, then I would urge a no vote on the motion and have Commissioner Rennie continue to participate. If he believes that he might be biased in the matter, then that would result in a different conclusion. In general, I would rather have people participate to the extent that they can. But I appreciate his caution, so that's my comment. Thanks.
Thank you, Commissioner, and thank you, Commissioner Rennie, for being the gentleman that you are. Thank you.
All in favor? Aye.
Aye.
Opposed? Hearing none. We have recently received a memo that is from Mr. Minette Shaw. We just got it over the weekend, and I confess I have not had an opportunity to sufficiently review it. Mr. Shaw, Mr. Minette Shaw, I don't know if I can ask you some questions about it.
You may, Commissioner Herr. Might I just draw your attention to the date of the letter? It should not have taken until over the weekend for you to have gotten it, but be that as it may, your questions?
Is this addressed only to this is addressed to both the complaint against Mr. St. Croix and
Both memos are virtually identical except towards the end.
But your view is they're directed both to Mr. St. Croix and Ms. Lediju.
Absolutely, and both of the two memos that I submitted dated September 19th pretty much, in a nutshell, indicate that because Charter Section C3.699-13 applies only to the ethics laws and not to the public access laws, as was held in the Alan Grossman versus San Francisco Ethics Commission Memorandum of Points and Authorities in support of a verified petition for preemptory writ of mandate, October 5th, 2009, which was settled in Mr. Grossman's favor. C3.699-13 was relied on by both the Comptroller's Office, i.e. Ms. Lediju, and by the Ethics Commissioner via Mr. St. Croix, as being their main claim that they had an exemption, but it is not upheld by CIPRA. And the majority of their case relied heavily on C3.699-13. And so because of that, I am going to repeat what I said in public comment of this meeting tonight, that I don't believe this matter should be before you whatsoever for a number of reasons, which I'll get to.
Oh, Mr. Minette-Shaw, I think the other thing I've realized is that the city attorney hasn't had an opportunity to review it either, and not his fault. Me not reviewing it is my fault.
Well, it's not entirely your fault, Commissioner Hurd, because the timelines.
Mr. Minette-Shaw, let me just finish. I don't think it's fair to you, or frankly fair to the process, at least from my perspective, for me to try to sort of read it on the fly and figure it out.
Absolutely.
So I would propose that we put it over, and I apologize to my fellow commissioners for that request. And especially with only 3 of us here, I recommend we do put it over. But I welcome the views of.
Well, this is an interesting turn, Commissioner Hurd. Supervisor Wiener has claimed that the Sunshine Task Force didn't handle their agendas properly. And so now that charge could be levied against the Ethics Commission as well. And if you're going to request a postponement, which I will probably entertain, all right,
Mr. Shaw,
I would like you to consider.
With all due respect, we don't need to consult you if we're going to put it over.
I know, but I don't think you should be hearing this case at all. In fact, your new regulations that you were just discussing indicated that my case should have been assigned to a different jurisdiction for the entire process. It's not that another jurisdiction gets to write a recommendation that then comes back to you, and while you still have a conflict of interest about the.
Mr. Minette-Shaw, I'm going to stop you there. I understand your viewpoint. We may put this over, and at which point you'll have your opportunity to speak on it. So
on whether it should be transferred to a different jurisdiction.
Yes.
Absolutely.
Thank you. Commissioners? Views? Okay to hold it over? In addition, I understand that there is precedent for the commission handling a matter that has been investigated by a different entity, a different body. I don't know, Mr. Shen, if before we take it up the next time, if you could tell me whether or not there is such precedent, that would be helpful.
Off the top of my head, I do recall one precedent. I think previously, maybe a couple of years ago, there was an ethics complaint filed against a member of the Ethics Commission staff. And at that time, we asked and generously received assistance from the Oakland Ethics Commission staff, which provided a recommendation that came back before this Ethics Commission to make the final decision on.
And so we did make the decision.
Right, and that's the only one that comes to the top of my head. I don't know if there are any others. Oh yeah, I think there may have been other, but that's the one that does come to my mind.
Okay. Okay. So in light of all this, let's put that over. Ms. Lediju, I apologize. Especially to you and Mr. Shaw for bringing this up now. Okay. The next item on the agenda. Do we take public comment if we're holding it over? Yes? Okay. Public comment.
Dr. Derek Kerr. I was one of the whistleblowers that reported misappropriations from the Patient Gift Fund. Mr. Monette-Shaw is accurate here where he points out that Deputy City Attorney Jerry Threet made an error in his memo, instructional memo, and it's easy to make that error because we had two whistleblower complaints, one involving a conflict of interest in a city contract and the other one involving misappropriation of patient funds from the gift fund. And Mr. Threet mixed those up. And this request for documents relates to a complaint about the gift fund. Misappropriations does not have anything to do with conflict of interest.
Peter Warfield, I am very disappointed that at 9:40 at night, we learned that something that was known at the beginning of the meeting is cause for skipping an item on the agenda. Perhaps the chair thought that he would be reading Mr. Monette-Shaw's letter and analyzing it sometime during the meeting. From what I know, I doubt it. My sense of him is that he's attempting to be very thorough and very fair. So I'm very disappointed that this couldn't have been announced at the very beginning of the meeting. Thank you.
Since I get public comment on my own item, I might as well avail myself of your 2 minutes worth of time. Ms. Lediju, I would like to apologize to you on behalf of Supervisor Wiener that you were dragged down here and thrown into overtime when it could have been avoided. Now, potentially, the city controller may have Ms. Lediju on flex time, such that she's not being paid time and a half for whatever her hourly salary is, whether that's $50 an hour or $80 an hour. Supervisor Wiener was quite perturbed that city employees' time was wasted in front of the Sunshine Task Force when respondents wouldn't show up. So I have to ask you, where is the San Jose Deputy City Attorney? Who's going to present her recommendations to you? How does that work when
she was going to appear by phone?
She was going to appear by phone.
Yeah.
Uh-huh.
Maybe that's who was trying to call.
Yeah. So because your proposed regulations say that you are going to transfer these cases to another jurisdiction as they come up, I'd like to remind the Deputy City Attorney, whose last name escapes me at the moment, that while you may have one precedent in front of you on how you've handled this in the past, that doesn't mean that how that case was handled in an ethical manner. So you may want to, this time, refer the whole case to the Oakland or Berkeley or San Jose Ethics Commission and let them hear the complaint. You shouldn't be involved in it. You are too close to your own executive director to hear and adjudicate this matter without a perception of a conflict of interest. So as you deliberate this, when you put it on your next agenda, I'm going to be back here asking you to transfer it to another jurisdiction so that I can have a fully ethical, independent review of both of these cases.
I believe I heard a suggestion that the city attorney provide the precedent for your hearing a case involving discipline of your own executive director. If the city attorney provides you with that information, I would hope it's made available to the public as well. I think it's important. Thank you.
Hope Johnson, I just quickly wanted to say that please take into consideration that it's not just a member of the staff. This is the the executive director who is managing all of the staff. And I think that that leads to a bit of a conflict of interest for you to decide to dismiss it or not and to send it over to a different ethics commission. The city attorney's office, I'll say, is technically supposed to have ethical walls, firewalls, but there was some question as to whether our own deputy city attorney for the task force could help us with some of these ethics commission matters. So that leads me to believe that there could be a conflict. So I encourage you to try to send it to a different jurisdiction based on the fact that it is a kind of a department head managerial employee. Thank you.
David Pilpel, I do recall the case. I don't actually recall the case, but I do recall that Dan Purnell, who was then executive director of the Oakland Ethics Commission, did perform this kind of investigation and recommendation on a prior matter where the staff was conflicted, and I think that was the case that Deputy City Attorney Shen was referring to. With regard to these two items, I believe that they are properly before you. You certainly can continue them to a future meeting, but I do believe that you followed and the staff followed the procedures for what happens where there's a conflict, and until we have regs to handle Sunshine referrals, these appear to have been handled consistent with the regs for handling investigation matters. So it appears to me that procedurally you're in a good place, and as to the substance, we'll deal with that at a future meeting. Thanks.
Thank you. Okay, one other thing I'd like to clarify for the public who think that I had decided at the beginning that we were going to move this and didn't notify you until now. That is not the case. I did not have an opportunity to look at it until the break. Realizing how substantive it was, I think I need to study it more, and I apologize again for the delay, but I think, to me, that's the better course than to do it on the fly. So, again, my apologies. The next item on the agenda is closed session. We don't need a vote to hold it over. We're holding it over. Right? We're good. Okay. The next item in the agenda is a closed session held pursuant to Charter Section C3699-13.
Can you anticipate how long this will take so we can judge whether or not to stay? Those of us who are interested in the following items.
I was going to say 3 hours, but I don't think it'll take long.
Thank you. I'll be outside.
6 hours or when I faint, whichever comes sooner.
Yeah, I'm sure we'll all keel over by then. Oh, can we move, is there a motion to move into closed session?
So moved.
Second? All in favor? Aye.
Aye.
Okay.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
Okay, we're back in public session. The charter provides that deliberations regarding complaints are confidential pursuant to section C3.699-13. Is there a motion that the Ethics Commission find that it is in the best interest of the public not to disclose its closed session deliberations regarding anticipated litigation? Did I do that wrong?
No.
Okay. Is there a motion?
So moved.
Second? All in favor? Oh, public comment? All in favor? Aye.
Aye.
Opposed? Hearing none. The commission entered into a settlement in the matter of Alex Torque, Principal Ground Floor Public Affairs, in the amount of $6,000. The order will be posted to the commission website tomorrow. The commission also decided that a matter would be referred to another department or agency that will handle the issue in a different manner. The next item on the agenda is minutes of the commission's regular meeting of July 23rd. Actually, we decided that would be held over, right? Okay. So we're not going to take up those minutes.
Okay, sorry, I'm back on the second disclosure. Can you disclose what the underlying matter was or what the agency is that the matter is being referred to?
I've been told no.
Will the letter of referral be available at some point, or is that to deem confidential under the relevant sections? I'm just trying to figure out what was...
This was discussion of a matter that's confidential under the charter, and so the commission's referral of that matter to another enforcement agency that's what the chair announced, that the commission is referring it to another enforcement agency. The details of that matter remain confidential under the charter.
And will continue to be so permanently?
The Ethics Commission's consideration of that matter will continue to be so unless and until the Ethics Commission issues a finding of probable cause, as the charter provides.
Which could still happen or would not still happen based on the referral to the outside agency? Unlikely?
If the Ethics Commission issues a finding of probable cause, it will be public.
Got it. And the other matter will be posted, you said?
The other matter is going to be posted tomorrow.
Looking forward to it. Thanks.
Executive Director's report.
Just one thing I wanted to highlight, because it's way at the end. Just another, I don't say just another, but another nice improvement on the website. What we're calling dashboards is a new way to access information that's on the website. It's already on the website, but in order to do searches that will compose not only reports tailored to what the user is trying to do research on, but charts and graphs that are very helpful in giving people visuals that support the information that they're looking for. So just wanted to highlight that we continue to work to improve the access of information by the public with various ways to manipulate the data that we have in our possession.
That's great. Commissioner Studley.
I'm sorry, I know the hour is late. But Jack gave me the perfect segue to information which is not in our possession, which can therefore not be manipulated by the public. This list secured, referred to in public comment earlier, of people who haven't filed their Form 700s. There's a whole interest by the public in getting this information. And there's also the fact that hundreds of other people did manage to do their forms at some personal inconvenience and sacrifice. And I think it's better that they feel that everybody was held to the requirement to do it. I appreciate the many responsibilities that staff have at a challenging time, and I realize we can't do everything in Cadillac fashion. But I wonder whether we could be more imaginative about things that we could do, simply preparing the list, having it in our, putting it on our website if we haven't done that, sharing it at a meeting with distress and asking people if they have thoughts about what we can do about it, just using the public value. You may want to remind us about what we've done to write to these people or follow up with them or give the list to the mayor and the people who do appointments of these folks to reappointments and things to other folks. So I know we've talked about this before, and it might be helpful just on the record to tell us what has been done, and for all of us to think about what we could do that could reinforce the seriousness of this without putting unreasonable expectations on a staff that's spread pretty thin.
Based on my prior directions to the staff, I understood that because of resources, non-filers were being referred to the FPPC, which does make enforcement assessment of fines in these areas. And state law is, their authority in this is clearer than ours is, because this is a state law. Okay. However, this wasn't being done, so I failed to follow up and make sure that my directions were being followed. And in fact, the practice is to send a letter demanding filing and then to send a second follow-up letter. When the second letters came from my signature, it was already mid-August, and I thought they'd gone out months ago. So again, that's my failure to have followed through on that.
I understand how these things happen.
But I'm taking full responsibility for that. But the practice should be, and in the future will be, that first we send people late letters, and we can assign them up to $10 a day for being late. Beyond a certain amount of time, beyond that, we have to assume they don't intend to file. And that's when we should be doing warning letters and referrals, but it shouldn't take 6 months.
I appreciate that, and I appreciate you telling us, what life is really like on the ground and taking responsibility for it. The back and forth of writing to somebody remains private, and if they're tossing all the letters, then nothing, we're stuck in a box where nothing is going to change. So Commissioner Han is the communication expert. Once you start communicating it to a wider audience, sometimes things crack loose or people feel, respond differently. So I think what you've said is good. We might want to consider as a commission what we want to suggest as, at what point do we post this or not make the public have to ask for the list but make it available, do other things that wouldn't be terribly burdensome but that could make your letter stronger by saying if we have not received a Form 700 by X or a Form 700 and the fine that you're now supposed to pay, this is what's going to happen.
And that's one of the differences.
Do I know whether these people would be embarrassed or feel awkward about it? I don't know. If the only punishment is you won't be reappointed to an unpaid commission with a lot of work, also a mixed blessing. But we think that our city's culture is to say we want people to do this and we will think ill of those who don't. And given all the many people we know who filed them because they're not on this list, there are folks who go, gee, do it, I did it, that might actually get us someplace.
Understood.
Thank you.
I want to thank the commission staff for doing an excellent job of posting the official misconduct documents quickly, and I mean, they were there, relatively easy to find, and thanks for keeping up with all that. I know there was a lot of stuff.
We had an interesting day last Tuesday distributing those over at Board of Supervisors.
I imagine there was a little bit of paper that was moved.
We had quite a
towards-
pile, and the cameras were out in force. Just to
You were being filmed taking the record to the
door to door to door on these big hand trucks.
Visual.
Hope you had a good tie on. Any public comment?
David Pilpel. Several things. On both the dashboard project and the posting of documents related to the official misconduct proceedings, IT Director Stephen Massey really should be congratulated. He doesn't get a whole lot of public credit, but he does a lot of the things behind the scenes that make this commission and staff work. And I just wanted to recognize that publicly. I'm sure he's embarrassed that I'm even saying this, but he really does do a lot of great work. On a couple of
Massey, if you're watching, thank you.
Right.
I hope you're not watching.
Mr. St. Croix tries at every opportunity to tell us the same thing, so it's good to hear reinforcement.
He's not the only one, yes. On some other points, I appreciate Commissioner Studley's concern about non-filers, and I have said many times before this commission, I would like to see on a regular basis, whether it's monthly, quarterly, every 6 months, periodically, a comprehensive list of all the people who are in a bad place, whether it's for not filing forms, not paying fines, being overdue on penalties. It's not just the form, with all due respect, it's not just the Form 700 filers and sunshine declarations. In some cases, it's lobbyists, campaign consultants, campaign folks. There are a lot of folks who get into a bad place, and we have never had a comprehensive way to track all that and say these folks are non-filers. We've tried. We haven't heard back. It would be great to do that, and if we could have some public mechanism for doing that periodically, I think we would actually see that number diminish substantially. As we see, for example, in page 2 of the director's report, where the BDR referral list is fewer than I recall ever having seen. So we're having some success, I would say, in getting folks off there, but in the past month there hasn't been movement. So on that point, item 8 includes an incumbent member of the college board, and I ask publicly if that person is reelected, will, in this case, he be able to be certified as a candidate if he has overdue fees, fines, forms, et cetera, and if not, that's a great example of where we should be proactive and saying that's a problem. And frankly, if our laws allow this person, and I have nothing against this person, but I'm just saying someone in this status to file for re-election even, having overdue fines, forms, fees, penalties, we should fix the laws so that they can't do that. You know, it's one thing if you're in office and you're fixing something, it takes a couple of months. If you're a candidate and you've got this much of that's kind of a problem, I think. And again, having nothing to do with the individual, just clearing things up so that you're able to go forward. I think that's it for the moment. Thank you for the long and interesting meeting.
Number 10, items for future meetings. Public comment. Public comment on matters appearing or not appearing on the agenda that are from the jurisdiction of the Ethics Commission. The meeting is adjourned.